Hello? Testing, testing. Testing, testing. Testing, testing. This one is not
Okay, good morning, ladies and gentlemen. Thank you so much for your patience, and welcome to today's FA's Community Dialogue focusing on child maintenance. And I just want to take an opportunity to also welcome all our online viewers. Thank you so much for joining us today. And I would also like to welcome our sign-language interpreters in this wonderful in this very water. Thank you so much for serving our communities. Just a reminder, if there's anyone sitting at the back who is deaf and would like to also make sure that they see the sign language interpreters, please do move to the front where you can see them clearly. Thank you very much. Just a reminder that this session is recorded and streamed live on StreamYard, and it will be available after the dialogue on all our social media sites, as well as YouTube and on our website as well. Well, we've actually had some really exciting things happening for the NPA SOCA Community Dialogue. As we all remember, on the 6th of May, we had our community dialogue focusing on the Domestic Violence Act, and that was quite a powerful session that we had. And something really amazing happened, but we couldn't share it with you then. But we actually had a member of our community who flew all the way from Pietermaritzburg to come and join us because she saw the work that we really had and she would like to actually take it to her community. And we really thought that was absolutely incredible. Again, so let's actually give a hand of applause for that. Basically, the NPA SOCA Community Dialogue is a community of, the legal fraternity, members of the public, mothers, fathers coming together to say, how can we solve the social ills that are affecting, especially women and children of this nation? It's just people like me and you coming together and say, what can we do to create the change that we want to see in our justice system? Ladies and gentlemen, most of us, especially women in this room, and those who are watching online, we have been wounded and failed by the justice system. Let's be real. We are carrying pain, we are carrying trauma that is caused by how we have been handled by the justice system in this country. But this community was birthed out of that pain and suffering. All the single mothers came together. They knocked on doors and said, come, help us, teach us, educate us, empower us. We're not going to wait for one day when things change. What can you do for us today? Just at least something. Give us a tool. Empower us so that we can at least go and fight for our children. And that's how this community was birthed. And today we are here. Last year, June, I came for the first time. And I thought, wow, legal practitioners, social workers, mediators in one room, passionate and still carry that true heart for justice. But why are we only here at the NPA? Does the community in South Africa know about these community dialogues? Are other provinces in South Africa hosting these dialogues to educate, to empower members of the public about child maintenance and the rights of the children and women in this country. Do we have other provinces in South Africa that are hosting this dialogue, this very important work? Fathers of this nation, where are you? Where are you in this dialogue? The legal fraternity is here. Social workers are here. Mediators are here. Mothers are in this auditorium. Fathers, where are you? Do you have a space in this community? Do you have a voice in this community? Do you have rights? Do you want to see change in the justice system? Do you want to play your part in making sure that our children are no longer suffering? Fathers of this nation, what do you have in your hand today that you can bring to this community to help us fight for our children? Do you have a seat in the table, fathers? Are you needed in this community? Is your role important in this community? What are you doing to protect, to provide? The great news is that 24th of June, we are going to be addressing the voice of the father in the maintenance system. And I want to challenge fathers, men of this nation, to come to this auditorium, join us, or to log in online and be part of that dialogue. I don't see fathers. How many fathers do we have in this auditorium? How many fathers are watching online? Fathers, where are you? Where are you? On a different note, I'm so excited to just share some of the amazing things that have been birthed out of this community. It is my absolute honor and privilege to announce that one of the delegates, she actually came to the dialogue on the 6th of May, and she's been crying out because there's such a need for mediation work in the Simon's Town and using the court. Then finally, after 3 years of her pushing, knocking on doors, finally, after the 6th of May, a door was opened in the Simon's Town and using the courts for her to carry out this project pro bono. We are so blessed to have you in this community. Thank you so much for your willingness to say, what do I have in my hands today that I can bring to this community to see change. Thank you so much. Ms. Tudor, this project is actually going to be launched on the 7th of June. Remember, Simon's Town and using the report. And if you would like to actually have a chat with her after the dialogue, she's over there. Do you mind just standing up so that we can see you? She is needing, though, more hands so that she could be able to carry out more of this work. So if you are an experienced and apprenticed family mediator, please do speak to her. Obviously, if you're touched in your heart to say, you know what, I actually want to sow something towards the community of Musenberg and Simon's Town. And I also just want to take a moment and thank the NPA and SOCA community for what they did on the 18th of May. They hosted a webinar. Ladies and gentlemen, we had all 9 heads of maintenance officers in one space talking about child maintenance. I don't know if that's something that has happened before, but I do want to take a moment and actually honor that and acknowledge that step and say thank you NPA SOCA for actually raising more awareness and really rising up to say we want to have more conversations, more dialogue on the child maintenance matter. By raising awareness, we are hoping that we're going to see more and more change. So I would like us to take a moment and just acknowledge that. Thank you very much. And in August, we're going to have our next webinar that will be hosted in Hong Kong. And then in September, there's going to be another workshop by all 9 advocates who are heading up maintenance offices in South Africa. And just another exciting note for our Father's Day, on the Father's Day dialogue on the 24th of June. We had an amazing psychologist, I'm sure most of you know him, Daniel Deon. He is going to be here, ladies and gentlemen, to address the fathers. You do not want to miss that. And also we had a wonderful workshop yesterday that was actually hosted by the deaf community about child protection, on Child Protection Week, and we had Advocate Bonnie Gamba, who flew all the way from Pretoria to come and address the community in Delft, and we also had Advocate Shireen Ibrahim also addressing the community on how we can actually better protect our children. Ladies and gentlemen, just few house rules. We all know that parking is available and complimentary all around the NPA building. If you haven't parked in the parking spaces that are designated to public prosecutors, which are free, all around Major Park Street, Candido Street, Pepper Street, please do speak to one of our ambassadors. They are all wearing these name tags. Just speak to them so that you can move your car, otherwise you're going to pay for parking in this icon. And buses are also available on this floor. Please ask one of our ambassadors and they'll be able to help you. We also have refreshments in the cafeteria and in the front, so you're welcome to help yourselves throughout the dialogue. And it is my absolute honor and privilege actually to welcome our first speaker for the day. I am so blessed by the work that you are doing in the Stellenbosch Law Clinic. Ms. Josie Haas, thank you so much for sewing into that community. Ladies and gentlemen, the Stellenbosch Law Clinic are availing themselves to help mothers in the Windens district. So you do want to make sure that you get the details. We'll give out the details afterwards. They are sewing into those communities, helping with maintenance applications as well as domestic violence applications. So let's put our hands together for our first speaker of the day, Ms. Josie. Thank you very much.
Good morning, everyone. Good morning. Thank you, Poppie, for the introduction. Before I start, I would just like to extend my gratitude to Adv Deon and his fellow ambassadors for extending the invitation to the Law Clinic to address you on this very important platform today. So before I start, I just want to mention that the information I'm going to provide today may not necessarily be applicable to you personally, but perhaps you have a family member, a friend, or a colleague, or a client that could benefit from this information. So I'm an attorney and the employee of the Stellenbosch University Law Clinic. I am the head of the Family Law Department. And the Stellenbosch University Law Clinic is actually a fully fledged law firm. So we function as any other law firm would. The only difference is that our services are provided pro bono, so our clients don't pay for our legal services. We are often confused with Legal Aid South Africa, which is an entirely different institution, but the principle is the same. Sorry, I'm just not sure how the...
We'll change to it.
Oh, thank you. Okay. So the types of matters that we usually assist clients with are divorces, which could be contested and uncontested, applications for maintenance on behalf of minor children, but only for the applicant, which is usually the mother. I'm sure there are instances where it could be the father, but it's mostly the mother. We do not assist the respondent, so the person who's defending paid maintenance. We don't assist those persons, only the applicants. We also assist clients with the application for a protection order due to domestic violence or harassment. What's important to note is that you do not need to seek our assistance from the start. So if you've already lodged an application for maintenance or protection order, and you are now learning about the law clinic, wherever you are in the process, we can help you from that point on forward. Very important to note that. We also assist with applications regarding the care and contact of minor children, drafting of wills. That's primarily what is involved in our family law department. Then we also have an eviction department where we assist persons who are being evicted from a property and not the ones who are trying to evict someone. Also very important difference. And then also applications for interdicts of minor mainfront schooling. So just as an example, I know that the term is a bit confusing. So if someone has taken the law into their own hands when it comes to property disputes, we usually help people remedy that on an urgent basis. And then we also have a general civil department, which deals with contractual, intellectual, and defamation claims. And then also bad debt cases and rescission of judgment applications. So if a judgment has been granted against you and you've now paid the debt in full and you need assistance with setting that aside, because a lot of people think if they've paid the debt, then the judgment won't be registered against them anymore. Not true. So we assist with that as well. So very important is, as a law clinic, we function on a pro bono basis, so we only assist qualifying clients. If we could, we would assist anyone in the general public, but we assist those who really need legal assistance and can't afford to pay for that. So we do have certain requirements. The first one is that you have to reside in one of these areas. What a lot of people might not know is that every university actually has its own law clinic. So at the Stellenbosch University, this is the area that we function within. But then there's also a law clinic at UWC, which is the University of the Western Cape, and the University of Cape Town. So each of them have their own area in which they operate, and ultimately we serve most of the Western Cape in that regard. And then the second requirement is that you have to pass our needs test. So it depends on your income. So if you are a single applicant, meaning that you are the only breadwinner within your household, then you have to have an income that is equal to or less than 8,200 Rand. If there is more than one person within the household who earns an income, then it has to be, the joint incomes have to be equal to or less than 9,000 Rand. Then we also look at whether you have fixed property. So if you don't have a fixed property, then the value of your movable assets have to be equal to or less than 151,700. And if you do have a fixed property, it's 711,700 Rand. So that means test is usually conducted during the first consultation. But what we try to do is if someone phones or emails to make an appointment, we try and ask these preliminary questions so that if we may not be able to assist them, we don't always want to waste clients' or potential clients' time in traveling to the clinic. So we might also request proof of your income by way of a payslip or bank statement, and then also proof of your asset value with municipal account, for example. So once you pass the means test and you reside in one of those areas, then we can assist you with any of the matters that I mentioned previously. Then, if you want to make an appointment, you can call the number that's listed on the slide or send an email, or you can just visit our office. We added the pictures because it can be confusing sometimes to find a venue. 18 to 24 Prosecutor Street, Stellenbosch. Okay. Then, what I'd also like to discuss is the social impact work that we do. So, this is very important. If you are affiliated with a school or an institution that you think could benefit from this, then please inquire with the email address provided. The workshops are also done on a pro bono basis. We do not charge anything. And we obviously provide all of the material and resources required. So the first one is our anti-bullying workshop. This is done primarily at high schools, and here the areas that I mentioned earlier are not necessarily applicable. So even if the school is in Cape Town or in one of the other suburbs, we will still assist with doing the workshop. So it's basically aimed at helping high school learners see each other in a more sensitive light, because obviously, as we all here would know, they are growing up in a much different age than we did, where they have social media and cyberbullying. So the workshop is basically aimed at raising the awareness of what the effects of that could be, and also making sure that they see each other in a more sensitive light. We've done the workshop at quite a few schools, and the feedback has been very positive. Then the next workshop we have is the Children's Rights Project, which is again aimed at primary school learners to educate them about their rights on a basic and childlike level, of course. So once again, this is open to any school, not necessarily the areas that I mentioned. And the idea is to educate them on what they should do when they don't feel safe. Who do they need to speak to? Because you know, as adults, if you tell a child no, it's a secret, they tend to keep that secret. So we try and undo that type of information on the child's level. And then the next project we have is the Financial Literacy Project, which is also aimed at high schools. Here we don't really address primary schools because this type of information might not yet be relevant to a primary school learner. And we also target farm workers. So the idea here is to give people some training and information about basic things that some people might not have, like their credit score, how to improve that. How do you even find out what your credit score is in the first place? What are your rights in terms of the Consumer Protection Act? And with regards to high school, our aim is more to educate them on how to start planning for their financial future. Because a lot of the schools that we go to, the learners don't have the information on how to apply for a bursary or what is NASFAS. So we give them the type of information that they need to start planning financially for their future. Once again, this is also open to any jurisdiction. All you have to do is send an email to the address provided, and we will assist, obviously, with the best of our ability. Then the next project we have is the drafting of wills. So as I mentioned previously, as a general practice, we draft wills at the clinic for any of our clients. But what we have started doing recently is if a hospital, hospice, or palliative care institution has bedridden clients who are unable to come to the clinic physically, they can also make an appointment for us to go to them to have their last will and testament drafted. This is, of course, a very important document, and people in that position might not have another opportunity to draft their will. So if you are once again affiliated with a hospital or hospice or institution that could benefit from this, you are more than welcome to submit the request. And then we also have our ESTA workshop, which is an evictions oriented workshop. So this is basically to educate community members residing on farms on their rights and their obligations when it comes to evictions, because a lot of people don't know how the process works. They think if the farm owner tells them, no, you have to leave by 31 January, that they actually have to do that. They don't know that there's a whole process that must be followed and that they actually just can't be evicted. So once again, this is not limited to jurisdiction. So if you know of any institution or any have any affiliation with persons who could benefit from this, you can send a request to the email address provided. And then the last one that we have is our constitutional rights training, which is aimed at educating persons on their rights in terms of the Constitution. A lot of us know what our basic rights are, but we don't always understand fundamentally what that means and what is allowed that could benefit from this or what is provided. So yeah, unless anyone has any pertinent questions that they want to ask, my email address has been provided and Poppie will provide it again. If you have any questions about anything that I've mentioned or just something else that you want to inquire about, you're more than welcome to send me an email and I'll try to respond as quickly as possible. Thank you so much.
So ladies and gentlemen, today we're actually going to do things differently. After each session, we're going to give you an opportunity to ask questions. So does anyone have a question for Ms. Rose? Okay, yeah. Do you want to come to the front so that the online viewers can also hear?
Good morning, everybody. Ma'am, I have experienced that I live out in Atlantis and I'm a Commissioner of Justice. And is that most people, I'm having extreme, do not have a constitution. They do not understand their constitutional rights. And in most cases, their basic constitutional rights is being violated. And people do not understand, and they come to us and they ask us to please help. And I tell people, we can only do so much. But you need to have a copy of the Constitution in your hand, study it, and know your rights, so that you can know when your rights is being violated, when you're being abused. And most people, as I said, do not have access to this, and I would really appreciate some kind of assistance to get prints, copies and prints of the Constitution to distribute to our people in our local communities so that they can empower themselves. I thank you.
I'd like to raise an issue around consumer rights. 2 years ago, my grandchild bought a washing machine at House and Home on the Black Friday. Since she got it, it was problems. Phoned in, I told her to have a paper trail. We did everything, even to the Consumer Protection Council. Nothing has happened since. So what is the next step? Because I thought I was going to tell her, we go stand in front of the shop with a board, and bring attention. Maybe they will act if we give them bad publicity. Because that would be my next, I was going to tell her this is our next step. Because they don't want to honor the fact of replacing this defective washing machine from day one. And they kept on fixing it, but it's not really being fixed. And so now she has a machine there that she can't use. So what's the next step? I don't want to be locked up by the mall where it is in Tukai. Okay, so what's the next step? 2 years and the warranty is gone.
Thank you for your question, ma'am. So, as an attorney, I am inclined not to give advice when I don't have all of the information, because this is obviously recorded and I don't want to say something when I don't have all of the information. So, what is important is, as I've mentioned, the best thing would be for your daughter specifically, if she's the consumer that's been aggrieved, to make an appointment with our office, bring the information, the slip, the correspondence that she's had, and then obviously during the consultation we will establish what the timeline has been and what can be done if anything.
Okay, thank you.
Good morning, everyone. So basically, my question is looking at, your constitutional rights, right? So closer. Don't you mind standing here so that, I can watch everyone? Yeah, okay. So basically, my question is, looking at your constitutional right, what type of services would, like the UCT Law Clinic or Stellenbosch Law Clinic, assist people, addressing major institutions? For argument's sake, like I'm a social worker in private practice, and when I was at the department, we had a lot of people that does not. Simple example, you've got the right to citizenship, right? But there's a lot of children that don't have birth certificates, that don't have ID documents. What is the process to fast track the when you do like a late birth registration? Because like that normally takes a long time, for social workers and for people to go through that long process. But yet you get like a person like Tabu Bester that gets it like immediately. You understand? So how would you address that? Thank you.
Thank you for your question. So I think when it comes to constitutional rights, it's important to remember that there isn't a catch-all solution for all of our rights in the Constitution, because you have different institutions that you would be dealing with. So, for example, if it's your right to housing, you might be dealing with the municipality. So there are different institutions and different routes that would have to be dealt with, similar to what you've mentioned, the right to citizenship. And that's why we do the workshop, because a lot of people might know what their basic rights are, but they don't know what to do with that information. Which institution do they go to? Which number do they call? Who do they send an email to? Who do they complain to? And that's why we have the workshop. Because it's very easy for me to tell you, you have the right to freedom, you have the right to dignity, you have the right to housing. But what do you do with that information? And that's exactly why we have this workshop, and why I'm encouraging you that if you know of a group of people, it doesn't need to be affiliated to a specific institution. If your community would attend and benefit from this workshop, and there's a hall somewhere that we would be able to use, we will gladly come and do the workshop for you to give you that information.
Wow. Thank you.
That's amazing. Thank you so much. I think there's one more question.
Morning, everyone. Good morning, Ms. Parks. Unfortunately, I missed your presentation earlier due to me assisting with the sign downstairs. There is one question regarding the means test that I have for you. If I can remember your presentation now correctly from, I think the day before yesterday when I read it, I think individually it's 8,200 a month, and combined it's 9,000 rand a month. Or if you have, excuse me, assets a combined of, I think it's, that I can't remember now. It's either 1 million or 700,000. Sorry, thanks. My question to you is, I understand there should be basics and there should be a means test, but for women that perhaps stay in that house together with the husband, they are separated, but there is reasons why she can't leave the house because she doesn't have an income, perhaps, but the house is still worth more than the 700,000. For instance, the house is worth 1 million rand. Now she's not going to qualify because she owns a part of the house, but she can't leave the house because she doesn't have any income. Will you look at cases like that? Do you look at cases on an individual basis, or is that means test, is that it? Is that, or do you look at it on an individual basis? So I think that is my question. Thank you.
Thank you for your question. So that's actually a very good question. Firstly, I want to just address why we have the means test, right? So if we didn't have a means test, then people who can afford legal representation would also use our services just because they could save money and they don't need to pay an attorney, which would mean that we wouldn't have the capacity to assist those who really need our assistance. What I neglected to mention earlier is that in divorce cases, for example, we often have clients that are married in community of property, so everything that they own is joint, and usually their joint income is more than 9,000. But in those cases, we look at the individual income instead, because we know that if you're going through a divorce, he's not going to help you pay for an attorney anyway. So then we would disregard that to an extent. But it depends on the individual merits of each matter. It's not a guarantee, but we do look at other circumstances. And as attorneys or heads of department, we do have the discretion, even if someone's income is a little over the limits that I've mentioned, but once again, it depends on the merits. So it's not to say that we will definitely help someone if their income is 12,000, but it depends on what their specific circumstances and needs are. So it is possible, because we do want to help those that are in a vulnerable position, but we also can't create the precedent that we would help everyone regardless of their income, because then we would have people asking for assistance that can actually afford it.
Are there any more questions for Ms. Cox? Thank you so much. That was really amazing. Ladies and gentlemen, if you require Ms. Cox's details, please you can come to me after the dialogue. I'm also just going to give them out now because this is recorded and you can always go and access this this session on our website www.talgayunasubject.za. It will also be available on YouTube as well. So the email address is jparks, so JPARKS at sun.ac.za. And the telephone number that you can use to contact the office is 021 808 3925. 021 808 3925. And I would really encourage the communities in the Winders area to really make use of these services. And again, Ms. Parks, thank you so much for sowing into our communities and for the work that you are doing. Thank you very much. Let's give Ms. Parks another warm hand of applause, please. We are going to have another interactive session with our very own Adv Deon Ruiters and ex-magistrate Mr Laurie Greyvenstein. And they're going to be having a discussion on the SA Law Commission paper 157, focusing on mediation. And I would like to welcome you both on stage, and we look forward to having this interactive debate. Thank you very much. Let's give them a hand of applause.
Madam MC, I need to apologize to you. We changed the program a little bit and I didn't notify you, so I humbly apologize to you. Because Mr. Eugene Opperman would have been part of the interactive session that we planned to discuss mediation and get people's opinion on mediation. And my wife keep on telling me I'm a quote-unquote mediator, so I've decided to leave it over to the experts. So I asked Mr. Laurie Greyvenstein to rather facilitate a session on mediation. He's the expert and he do all the training nationally all over South Africa. So I'd rather leave it to the experts instead of bringing a court book advocate and a court book mediator in. I left it over to Mr. Greyvenstein to do that part. Instead, I'm going to do my section now. My section is chapter 9 of the Law Commission paper 157. So that's what I will be dealing with, and that's on page 20 of the handout that you have in front of you. So if you go to page 20, you'll be able to follow what I'm saying. I just want to tell the online viewers that the handout that was sent to you and that all of you will have online is not as colorful as the one that we have in person for the people that are in the venue. And that is all because of our ambassadors that said, no, Deon, your stuff looks too plain and simple. So they decided to color it in for me and make it look the way it looks over there. So the one that you're seeing is much more colorful than the handout. So the online viewers, unfortunately, it's not that we criticize you. If you were here, you would have seen all the colors and all that we have, but that is only for our in-house listeners and delegates that will have that nice, beautiful, colorful one that we are dealing with. So as I said, I'll be dealing with the SA Law Commission paper 157. That is chapter 9 of the Law Commission. And the reason why we're doing this is for us to have a better understanding of what paper 157 is all about. Now, paper 157 is all about the changes that's going to happen in the maintenance legislation and all of it. Mr. Arns, I see you smile at least today with me, and it's maybe because there's questions and all of it and interactive, because the 6th of May on our domestic violence session, Mr. Arns was sitting where Ms. Parks is sitting now, and he was giving me all the dirty looks. Him and my wife were busy preparing how to look at me to show you I'm not happy with that, I'm not happy with that. So Mr. Arns is smiling today, so we're doing one thing right today. But paper 157 is for the first time that civil society will be able to participate in a participatory process in Parliament. All along, we are always saying that legislation is not working for us, people are making decisions for us. For the first time, we will be allowed to be part of that participatory process. So there's no more thing that we're going to go on all these Facebook groups and say, yeah, but the law is not caring for us, the law is not doing anything for us. If the law is not doing anything for you, it's because of yourself and because you don't want to be part of that process. The NPA have been offering these services for the last 2 years, where we have these interactive sessions where we educate the public about their rights. We make sure that there's a handout for you, and we've been going through the whole paper 157. Mr. Greyvenstein will be assisting me today as far as the chapter 2 dealing with the mediation in maintenance policies that is being recommended by the Law Commission. So the broader public is getting all of this information. Now it's up to you whether you want to be part of that process yourself. So there's no excuse that you're going to go on Facebook and say, no, the justice system is not working, this is not working. If anyone is saying that the justice system is not working, it's because you don't want to make it work for yourself. And that is where I challenge every single one, online as well as in this venue today. We have chapter 9, there's 5 more chapters that we will be discussing over the next 5 months. We won't be discussing it next month. Next month we'll be doing the Voice of the Father facilitation, where we're going to get fathers to come and speak and about say how they've been marginalized in the process of, all right, shoot, Mr. Archie, your neck is going to go off the way he's agreeing with what I'm saying. So what I'm saying is we're going to get fathers over here, and I know there's mothers that's going to be angry with me, but I make sure there's extra security that will be standing around me. I've dealt with more serious cases where people wanted to kill me, so I've got my friend Mr. Eric Alverson over there. He's a giant. He will always protect me. So, and he's a mediator. He will mediate. Please now, don't hit Deon. So I will have some protection from Eric. Eric, can you just stand, please, so that they see who you are and how tall you are. So if you want to ever challenge me or do anything, I'll just tell my dear friend and mediator. He will help me and sort that out. As far as anyone wanting to hurt me, Nikki's always over there at the back to look after my back, so I'm covered. Be it as it may, you will have no excuse in participating in the law commission process. Over the next few months, we're going to teach you how you can file your own decision, the what that I will be discussing. Unfortunately, chapter 9 is the shortest chapter in the Law Commission paper, and I think it's actually supposed to have been the longest chapter, and not the 32 pages that have been dedicated to mediations that Mr. Greyvenstein will be dealing with a little bit later on. Chapter 2 deals with almost 32 pages of what we can do in order to make maintenance better in South Africa pertaining to mediations. But this chapter, chapter 9, dealing with civil recovery, is one of the shortest chapters. It's only 2 pages, 2.5, 3 pages, the most that chapter 9 of the Law Commission paper is. If any of you want to have a copy of paper 157, the Law Commission paper, there is, you'll see over there at the back some posters with barcodes that have been put up. Also in the lobby in front, there is these barcodes that you can just use your cell phone, smartphone, and then you'll be able to scan it in the online viewers. There is also those on the handout where we embedded the QR code for you to be able to then also get the paper 157 in case you want to read paper 157. Those of you that are lazy to read, you are in good hands. I will be going through that few pages so that you will be able to at least have some idea what paper 157 is all about. Yes, there is the barcode that you can scan in case you'd like to have a copy of paper 157. If somehow your cell phone, while you're zooming in and out and it's not working properly for you, then what you can do is just go over there at the back and you'll be able to also scan it in the auditorium. And Nikki this morning, 8 o'clock already, before load shedding started, she put all the barcode posters up in the lobby. Thank you, Nikki, for all your hard work. 8 o'clock this morning, she was already over here with me. Nikki, can you please stand so that people see who you are? She's our youngest volunteer. She is 81 years old, but the youngest at heart. She doesn't have even a case in the maintenance courts, but she have been over here every single of our community dialogues. She's been over here in spirit with me, always typing my PowerPoints and typing my affidavits. All those affidavits that you asked, where did John get the time? There is my time over there at the back. She's my left and right hand. She always do all of those type of things for me. Okay, let's quickly get to the next page, Annika. What we've discussed so far of the paper 157, Meryl, we went overboard now. I didn't even see all of this. Paper 157 deals with how we're going to change maintenance in South Africa. What are some of these stumbling blocks that people are sitting with and struggling with in the maintenance courts over the last 25 years? The Maintenance Act was promulgated in 1998. That's 25 years ago. A quarter of a century ago, this piece of legislation was brought about by Parliament. Only 8 years ago, in 2015, September 2015, we had the Maintenance Amendment Act 9 of 2015. That's the only amendment that happened over a quarter of a century in South Africa. In 2011, 11 years ago, the Minister of Justice, at that time, Minister Jeff Radebe, wrote an email or wrote a letter to the Law Commission. And in that letter, he said,
we need to prioritize maintenance in South Africa. It took 11 years till May 2022 for us to get the Law Commission Paper 157. And that is where we are today. We are busy dealing with it. We've already gone to some of the chapters dealing with mediation, but Mr. Greyvenstein will assist me to go to chapter 2 again, dealing with the mediations in maintenance, as well as the duties of maintenance officers, because the Law Commission is recommending that maintenance officers and public prosecutors should also be conducting these mediations. There were only a few of us, 38 of us, that commented on the Law Commission paper, of which Mr. Greyvenstein, myself, my wife, I think Annika also contributed, Mr. Opperman contributed, Liesel Cornier contributed, Mel was very vocal in our us that will be doing Section 10.6, very vocal during our deliberations with the Law Commission, where we gave our opinion on mediation and whether maintenance officers will be in a position to deal with mediations in the way that the Law Commission proposed it to be done. There is at the back, there's a board. Can somebody just go to the back and just put on the lights, and then on, and all the lights will be able to go on that board. So we've gone through all the chapters from chapter 1 up to chapter 8, and that's where we are today with chapter 9 of the board. Can you please excuse me if people tap that thing at the back and everything was going to go? Just give me 5 minutes. I need to sort it out. Sorry for the online viewers. We are having load shedding in Cape Town. So that's why all the things quickly start, and I had to quickly go and switch it on. For our in-person people, we will just wait out there. Meryl's back online, so we can then continue. Meryl, I didn't know it's going to be this colorful. But, okay, then chapter 3 deals with the, I know she's a school teacher, deals with the determination of maintenance awards. And what is recommended is that we should look at other things like payment in kind, where the person is unemployed, person can't afford to give a monetary award, and whether that person, if he is dealing with livestock or he's dealing with something else like selling fruit and vegetables or anything like that, then whether he can give payment in kind. Some people, or my colleagues up north, when we discussed the recommendations, they said we can't use the word payment in kind because it has some other connotations to it. We all know what that is. So the payment in kind is not what you think. Those people that are laughing also know what is being meant by it. But payment in kind means if he's into livestock, then he should bring that extra chicken that they can prepare and then have the readily available, or in a case where the person is having a fruit stall, that he brings some vegetables to it. That is the payment in kind, and not what you were laughing for now. But that is the idea that they have with the payment in kind that is discussed in the chapter 30 as far as determination of maintenance awards. The one that is my wife's favorite is Lucas Standi, and how Lucas Standi will look in future. Lucas Standi is the right of appearance. Who can apply for maintenance? Can an aunt that is taking care of a child apply for maintenance if the mother is using drugs or the mother passed away or whatever the case might be? Lucas Tandy also deals with the case of mothers that are taking care of their children, and when they reach the age of 18, what is then going to happen to that child? Must the child apply for himself or herself, or are that mother still going to then be able to apply on behalf of the adult child? There's an article that was written in the January-February edition of the Rebus. So if you Google the Rebus, DEREBUS, the Rebus, two words, DE is the first word, the other word is Rebus, REBUS. In the January and February edition of the Rebus, you will find an article written by our very own Natalie Ruiters on how mothers can apply for maintenance of adult children above the age of 18. Right now, there's this thing amongst maintenance officers: when the child turns 18, the child have to come and apply on his or her own behalf. That's nonsense. It is untrue. That was changed in the 21 July decision of Z versus Z that was heard in the Supreme Court of Appeal. The Supreme Court of Appeal, 5 judges found that a mother can apply for maintenance on behalf of her adult child. So it's not a thing that they cannot, the mothers cannot apply for maintenance on behalf of the 18-year-old. So if the child turns 18, there's nothing that stops that mother from continuing with the case. The only problem with the Z versus Z case in 21 July was that it was decided in the divorce court. So some attorneys used this and took advantage of it and went as far as saying, no, Z versus Z is only applicable to cases in the divorce court and not applicable in the maintenance court. That was sorted out the 19th of October last year, 2022, by our very own Justice Saldana and Judge Erasmus in a case DWT versus MT in the George Circuit Court, where the George Circuit Court found that mothers can apply for maintenance of adult children. They do not have to replace the mother with the adult child anymore. So if any of you and our online viewers ever have a case of an 18-year-old or a 19-year-old that is not getting maintenance and the mother's taking care of that child on their own, please tell them they can go back to court and get a court order, despite the fact that that child is over the age of 19 or 20. In the Z versus Z case, the children were 23 and 25 years old. So if you are sitting with a 23-year-old and he doesn't want to have anything to do with his father or his mother, and there's only the other parent taking care of that child, there's nothing that stops that mother from applying for maintenance of the 23 or 25-year-old child on behalf of that child. Because sometimes what happens is the child don't want to have any relation with the other parent because of whatever issues there are, and then that comes to it. I'm spending too much time on Lucas Tandy now, but that's my wife's. I hear that every night. Luckily, she's not here to hear that. But every time I must hear that. So now I'm telling the whole thing over to you. Then the appointment of maintenance officers. There's a problem as far as Section 4 and Section 4.1 and 4.2 of the Maintenance Act. Section 4.1 have prosecutors deemed maintenance officers. Section 4.2 have the Department of Justice maintenance officers. Nou, in Afrikaans, there's a saying, tussen die hand en die mond val die pap op die grond. And that's unfortunately what's happening to maintenance matters in South Africa. On the one side, you've got a Department of Justice maintenance officer dealing with the case. And if there isn't a maintenance officer at a specific court, then the prosecutor will tell the members of public, no, there's no maintenance officer, you must come back another time. That's what happened in the North Gauteng High Court, where a matter of Anna Mutimunye had to be decided. in this matter of Anna Oma Mutimunye, Ms. Mutimunye went to a court looking for somebody, please help me and attach and take this person's pension. And the prosecutor told the lady, Ms. Mutimunye, no, there's no maintenance officer over here. You must come back some other time. And she came back at least 5 or 6 times and nobody helped her because there wasn't a maintenance officer. The prosecutor over there didn't even know that he's deemed a maintenance officer in the absence of the a maintenance officer appointed in terms of Section 4.2 of the Maintenance Act. Part 26 of our NPA policy says that a prosecutor is deemed a maintenance officer, and in the absence of a maintenance officer appointed by the Department of Justice, that specific prosecutor become the maintenance officer. And that's what happened in Ms. Mutimunye's case. Unfortunately, the prosecutor keep on telling her, no, come back next day, maybe the maintenance officer will be here. Eventually, the pension was paid out and Ms. Mutimunye sat with nothing. Luckily, Ms. Mutimunye had a family member that was in the Department of Justice. Unfortunately, the broader public do not have that luxury of having somebody in the justice system to help them and tell them, go and sue the Department of Justice and make sure that you get that help. Luckily, Ms. Mutimunye sued the Department of Justice and she managed to get all the arrears back because of the negligence of a prosecutor not standing in. So what I'm telling to you and the public is, whenever a maintenance officer is neglecting to deal with your case, you have a civil recourse. Use the Anna Mutimunye case in case any maintenance officer or prosecutor don't do what they do. The Law Commission is discussing it and saying that what is happening currently is tussen die hand en die mond val die pap op die grond. The one is blaming them, no, you must speak to the maintenance officer by the Department of Justice. Prosecutors is saying, go there, and the maintenance officer is saying, go to the prosecutor. That's when the porridge is falling to the ground. I'm just translating now, it doesn't say that, but okay, that's what it means. But in Afrikaans has got a good way of saying the thing, just the way it is. English don't do that. But the Afrikaans speaking people understand what I'm saying. So now, that is the issue. Where must maintenance officers be so that we don't have this nonsense of, no, it must be the prosecutor that must do it. Prosecutor saying, no, it's the maintenance officer that must do it. So if you have any of these experiences, then this is what you will bring to the portfolio committee. And you can do it in writing or you can do it in person where you can come to Parliament and do it. So our online viewers that are up north in Gauteng and KZN or all over South Africa, they can always submit to the Justice Portfolio Committee that I will discuss around August or September this year. How do you submit that presentation of yours? And where you tell us what happened to your case and what went wrong in your case. Valdela, I heard the other day on one of the webinars where you said what happened to you in the 80s. Now, we need those type of experiences where you've been failed by the law, by the justice system, and how we can fix it. We cannot fix Mr. Fraser's case anymore, but still she's trying every single day to help other people in Manenberg. So all of us might have a different story where we've been failed. But if we're going to keep quiet and not say anything to make the system better, then you belong where you are to sit there and complain. Then join a support group. We've got a beautiful support group, 300 of us over there. We can any day say to you, I'm sorry, we're there for you. But if you're not going to stand up for yourself and say, this is what's wrong with the system, and this is how I feel we can change the system, then it's up to you. And that is the reason why we have been discussing these different parts of the legislation over the last few months up till now. And I think we get to the next slide. Okay, so what we're going to be discussing today is the civil recovery. Now, what usually happens is whenever a person is in default and he doesn't pay his maintenance, then you can then apply for that person's salary to be attached, his pension to be attached, or we can take whatever assets he have in terms of Section 27 of the Act. Now, all of that is dealt with in terms of Section 26 of the Maintenance Act. Section 26 says that where a person that is supposed to pay maintenance is in default for 10 days or longer, then you can come to the court and apply on a J306 for the enforcement of that order. There is an example of a J306 at the back of your notes. Will tell you on which page it is a little bit later. On page 26, in the middle of that page, on page 26, you will see the different types of attachments that you can do. The first attachment is attachment of emoluments, that's in terms of section 28, or you can attach assets, that's in terms of section 27, or you can attach a pension fund or retirement annuity of a person, that's in terms of section 30. And all of that you do on a form called the J306. The J306 is the enforcement of the order. Now, that is how you usually will start with that whole process. Now, the first form that you complete, slide 6 on page 21, the first form you complete is when the person is in arrears, you complete a form that we call a J470, 470. If you are looking for it and the online viewers that don't have a copy of the handout can then look at on Google and just put in J470 maintenance complaints form. If you Google J470 maintenance complaints form, you will get to that form that is on slide 6 on page 21. Now, that is where you first complain. You were supposed to pay maintenance and he didn't pay for the last 10 days. I've been waiting, I've been sending him WhatsApps, please pay. Then he sends, what's a and all of that nonsense that they send to you. I'm not swearing because this is what the ladies say, some of the people are saying to them. So if any of you have any of those type of cases, keep those snapshots because then we've got what we call misconduct or willingly not contributing to it. Because as soon as they get that summons that we call a J605 or J50 warrant of arrest, then they changed their tune. They said, no, she must just speak to me, but she didn't tell me that she needed immediately, even though there's a court order. They come up with all the flimsy excuses when they get to the maintenance court and they've been summoned to court. But let's quickly go through the process. First, if they complain on a J470, that's on slide 6. And then the most important one that you will get is the J306, that's on slide 7, also on page 21. If you need a copy, just look for the copy on Google by putting in J470 complaints form, or you put J306 maintenance form, then you will get to it. It's also on the back of your notes, page 26 onwards. You'll find some of these forms in case you are looking for a copy of a J470 or a J306. Those are the most important ones that you need to deal with. Okay, so now in your J306, you will make a decision which you want. Do you want them to take these assets, or do you want them assets we take in terms of section 27, or then we can take his emoluments, that's in terms of section 28, or we take his pension or retirement annuity in terms of section 30. Now you need to, on the J306 on page 26, you need to mark whether you want to take his assets, or whether you want to take his emoluments, or whether you want to take his a pension. Sometimes mothers haven't had contact with the father for years, don't know where he works, what assets he have, and all of that. The Law Commission says that in a case where you are not sure, let the investigation first be done, and then they make that decision. Unfortunately, all our maintenance officers haven't read the paper 157, so they say, "Nee, you must put something there." And unfortunately, all of us don't know what the assets of the respondent is. We don't know if he's working, where he's working, or whatever the case might be. So it's difficult for us or for members of public to choose out of this basket what is the best one to take. I wonder if I should take his car, but we don't know if the car is fully paid or is it still the bank's car or whatever the case might be. So because of all of those type of things, it's difficult for anyone to decide. And the Law Commission dealt with it and had to make a decision whether it will be viable to let it over to the applicant to say what to do, or whether it is going to be in the interest of justice that a maintenance investigator first do his maintenance investigations, and the maintenance investigators do their investigations by completing ITC request, where they will go to his ITC background. If you know he's got a car, mention that he's got a car. Then we will do an e-notice record. E-notice will show all the cars that was registered in his name over the last few years. All of that will be on the e-notice. Then the other thing that the maintenance investigator can do in terms of Section 7 of the Maintenance Act is they can investigate the bank statements and all of those things of the respondent, and they can summon any of the 5 major banks in South Africa, but not some of the other foreign banks and things. Only the 5 major banks: Standard Bank, Absa, Capitec, First National Bank, and Nedbank. Those are the major banks that we can investigate. If it is a person from Mozambique and they go on all of those other sites where they do it, then it becomes more tricky and difficult for our South African maintenance investigators to do their investigations. Also, in terms of Section 7, a maintenance investigator can do tracking and tracing. As soon as you get to the maintenance officer and you don't know where the person is staying, the maintenance officer or the maintenance clerk will tell you, no, we need an address. That's the biggest nonsense. All you need to make sure of is make sure you've got the ID number of him. With the ID number, we can do an e-notice, we can do an ITC, we can do bank statements, all of it. We can summon all 5 banks with the ID number of the person. So if they ever tell you that they can't be looking for him because they don't know, that's nonsense. Section 7 of the Maintenance Act says they've got a duty to track and trace the respondent. All you need to know is, and please, for our online viewers and for our mothers over here and our mothers that have daughters, tell the mother, your daughter, the first time she's got a boyfriend, he must come with a copy of his ID before he gets into your house. If you do not have a copy of the ID, if you don't have a copy of the ID, you do not allow him in the house because you need to check. And even if you say, Mama, you don't do all of it, you do it. You say, "Kastaks nie op die televisie." Say, "Klinkie inkom, then I've got proof why I want it." Make sure you've got a copy of the ID. And the other one of us that are getting into a relationship a little bit later on, and the guy comes to you, then the first thing you ask is, can I please have a copy of the ID? Make sure, and he says, sweetheart, don't you trust me? And he says, yes, I trust you, but I just want to keep it just in case something goes wrong and I need to go and look for you. Then I can tell the police, here's his ID, then I know who I'm speaking to. But you don't tell him that you actually need it for maintenance, to make sure that the maintenance investigator can do an e-notice or a ITC or whatever else is needed in that specific case. So those are what you do when the person is in default of the specific order in that specific case. Page 22, then what we will look at on slide 9, emolument attachment orders. There was an amendment to the Maintenance Act in September 2015. September 2015, the Maintenance Amendment Act said now in Section 28 1D of the Act that whenever it comes to emolument attachment orders, then there is no need for that specific order to have a notice period. Magistrates all over South Africa have this thing. Whenever you bring a J306, there must be a notice period, meaning there must be notice given to the respondent, telling the respondent, listen, these people want to take your assets, so you must please come to court and come and fight them over here. Otherwise, I'm going to give an order doing that. That is what they call motion proceedings. The other option to motion proceedings is ex parte applications. Ex parte applications is where the court can give an order based on the affidavit that you submit to the court. So if you submit a J306, submit an affidavit in which you say he's in arrears for more than 10 days, and I know he's got a car, take that car, or whatever you can say in that. But there's nothing that stops the court from applying ex parte applications. But in most cases, the magistrates will say, no. For fairness, it must be a notice period where you give notice to the other person in order for that attachment to take place. Because of that notice and all of that, Section 28(1)(d) of the Amendment Act 9 of 2015 was then promulgated by Parliament, which says, and this you find 7 times in the Maintenance Amendment Act. Don't know where Meryl put it. It's somewhere in there, but it is on slide 7. There's a small thing in the middle of slide 7 on page 21 that says, provided that the applicant will suffer detriment and a delay is an unreasonable delay. In all of those cases, then the court can give a order immediately. You do not have to wait, provided that the applicant will suffer detriment and it's an undue delay. In all of those cases, then you can apply for an immediate emolument attachment order. That is on slide 7 on page 21. That JTO 6, the next slide. Yeah, this part. Provided that nothing precludes the court from making an order in terms of this subsection if it is of the opinion that any further postponement of the inquiry in order to obtain the evidence of the persons referred to in paragraph D, that's the applicant, will give rise to unreasonable delay in the finalization of the inquiry to the detriment of the person or persons to be maintained. So all you need to put in your affidavit, number 1, is that is in default for more than 10 days, and you want an immediate emolument attachment order, because if they're now first going to give notice to the respondent and to the employer, it's going to cause an unreasonable delay and the children will suffer. It will be to the detriment of the children. That's all you need to show when you complete it. Always make sure that you have an affidavit. On our group, www.childmaintenance.org, there's a lot of different examples of affidavits. Look for founding affidavit. In the public tab, look for founding affidavit. You will find all the different affidavits that you can think of is available free of charge, and you can download all of it for yourself in case you would like to get all of it. So that is what the Law Commission then decided, is that we need to make sure that the applicant don't need to look for a basket of saying attachment of assets, that is section 27, attachment of emoluments or salaries, section 28, or attachment of pension or retirement in terms of section 30. Don't have to do any of that. Maintenance investigator first do the investigations, come with a report with the ITC, e-notice, and the bank statements, and say, no, but we found that on the ITC that he's buying on credit at these places, therefore he must have some type of means. Or else on his e-notice, he's got a car, he's got a bakkie, he's got a caravan, he's got a trailer. All of those things we can attach in terms of section 27 of the Act. So all of these things can be dealt with in terms of the civil recovery. That is what is being discussed by the Law Commission. Unfortunately, as I say, it's only 2 pages, and I think the Law Commission could have done a little bit better. I did file my submission. My wife also submitted, as well as Mr. Greyvenstein. I've seen some of the work that have been submitted. The negative thing about the Law Commission paper is that, number 1, or what I feel that the Law Commission could have done a little bit better, is section 27. In terms of section 27, and I would like you all to listen, and the online viewers, section 27 says when you attach a car or asset, then the poor lady will have to somehow pay 5,000 or whatever the sheriff fee is to take hold of that car and put that car in storage until it is going to be sold at an auction. Nowhere is there any type of resource, because a mother do not come to court because she loves coming to court. And she's not coming to court out of her own free will. When she comes to court because she's got a need. You cannot, when a lady is completing a J306 and saying that I want to attach his asset, then still saying, but where's the 5,000 security fee for the sheriff? Where must she get that money? and that is not being dealt with the civil recovery. It's not in any way mentioned in any of the 300 pages of paper 157. So one thing that I feel should have been done is that we need to make sure that mothers are being covered. Section 28 of our constitution, I've got a copy of the constitution for you, I'll give it to you. Um, uh, and for Women's Day, I'm going to ask our Director Court Operations to make sure everyone that's in this venue will get a copy of the Constitution, sir. Might be a little bit outdated, too, but let's first finish the old ones and make sure that there's not a few more trees that's going to die because of making sure everyone get a copy. So let's use all of those old copies. We'll tell you where it is being amended or changed. But for August month, I'm planning something special or not. My dear colleague, Ms. Pongelwa, is busy with a special program for women for Women's Day. My wife is, the two of them are in cahoots. They are busy getting all the speakers. So please come in August, and everyone that's going to be here will get a copy of the Constitution. My wife says it's going to be leather bound. I don't know where they're going to get it. It's their thing. I don't know where the poor Department of Justice is going to get that, but the stakes are high. It's going to be leather bound. So please make sure. The one I've got is paperback. So please, I'm sorry. You need to speak to the ladies in front if you want to have a leather bound one. But the Law Commission could have done a little bit better as far as making sure that Section 27 also deals with how women will be able to do it. There is good news in page 40 of the uh, Department of Justice's Code 26 of 2015. The Department of Justice has a policy document called the DOJ Code on Family 26 of 2015. On page 40 of that document, 40.1.5 says that uh, the maintenance officers, when a lady comes with a J306 and she take the A and say she want to take the assets, then the maintenance officer have a duty to do a inquiry, ma'am. If you want us to take this car, then in terms of law, you will have to pay the sheriff's fee. Will you be able to afford it? And I can tell you now, most maintenance officers don't do that. They will never ask, ma'am, can you afford it? They will just give you a copy of the warrant of execution that you need to take to the sheriff, and the sheriff will then tell you there, you need to pay 5,000 for them to go and take the car, put the car in storage for the auction to be held. Once the auction is held, and they sell the car, then the proceeds of it will pay for the arrears, and then you will get your fee back. That 5,000 you can get back depending on the proceeds of the auction. They will tell you that. But that is a little bit too late because when you get there, you need to have that 5,000 in cash before they're gonna deal with your case. But I'm telling you now, the Department of Justice have a Family Code 26 of 2015. In each library, in every magistrate's court, that document should be there. Family Code 26 of 2015. I've seen some copies, some people have copies. There's a lady sitting right in front, Miss Lieselton here. She's got her copy, so if you want to get a free copy, steal her copy, then you will have your own copy of it. But the Family Code 26 of 2015, on page 40 of that document, 40.1.5 says maintenance officers must do an inquiry and find out whether the lady can pay for it. But in most cases, they will not tell you that. The other more important thing that the chapter 9 deals with is that period that happens after the court made an order, the rule nisi order. Usually that is takes 2 months, or it can take 5 months, it can take a year, depending on when it's served on the person. And the service must be in person. So if they can't get hold of him, then the court will either remand the case till another date or another date until he signed that he knows that there is impending attachment that is going to be done. The Act says that if it is served on any person over the age of 16, then that is a proper return of service. Then the court will accept it. There's a case that was decided that Mr. Opperman did an article in the Darabas last year, July or August, VDB versus VDB. In that case, Judge Sewendo said that in a case where they're staying in these flats where you can't get in because they tell the respondent tell the security, "You don't let anyone in over here for me." So now the poor security guard is put in the middle, and the security guard is saying, "Nee, daai man het gesê niemand gaan die in nie." So now nobody can go into a place to serve that document on them. Judge Sewendo in VDB versus VDB last year said that you don't have to do all of that nonsense anymore. You serve it on the security. The security must serve it on him. As long as we've got a proper return of service, that is enough. There's another case, Sibeko versus Shackleton Investments. In Sibeko's case, it says that in a case where you can't get hold of him, then email it to him. As long as there's some type of service, then we use a different form of service. We call it substitute service. That's in terms of Rule 9, subsection 9 of the Magistrates Court rules that also say that we can serve in any other way than that. So civil recovery, the lady have to wait so long after she complained for this notice to be served that there are more arrears that occurs. In most cases, whenever a case is being dealt with, please update the arrears. Don't just complete one J474. May was 2,000 in arrears. Then there is my goed lê by die hof. It is lying at the court, but you don't think of the next month, April or June's arrears, July's arrears, while you're waiting for this to be served on him. And that is what Chapter 9 deals with. There is a gap between the time that when it's served on him. But when the case is in front of the court, the magistrate is bound as and the emoluments, then you want to come and say, you must know 6,000 in arrears. Then the court say, well, the last document we have is 2,000. So what I would like to encourage the online viewers as well as you sitting over here is please update that arrears every time that is due and payable and he didn't pay. Let the court know about it. Because if you don't, they will sit with the wrong arrear amount and then you're going to struggle when that order is being made by the court. If the court makes a wrong order, it's because of you. It's not because of anyone else. You need to update that arrear amount. And if you're not going to update it, then obviously there will be problems at the court. Page 22, slide 22. So the default that the Act says is there is, next slide, next one. Next one. Yes, this one. So the Act doesn't deal with future defaults by the respondent. They only deal with the last one that you submitted. So if you don't update it, then obviously they will not know of what the new amount is. I underlined over the word automatic adjustments. The Law Commission recommend that we automatically, or the court can automatically adjust the arrear amount without the lady coming there. We are not there yet. So don't go and ask, nee, ek het gehoor, it's an automatic adjustment, jy moet adjust daar. So it's not going to work like that. The maintenance officer is going to tell you, come nonsense party, Mr. Right, that's what nonsense, I hear that every time. So you're going to hear that too. There is no automatic adjustments yet. So the only way we're going to get there is if we keep on updating it and putting in a supplementary affidavit in which you say that in March when I complained it was 2,000, the new arrear amount is 6,000. You need to inform the court, otherwise the court work with old information. If the court work with old information, the magistrate is going to tell you straight off, well, ma'am, here's only this March document for 2000. I don't know any of what you're talking about. And don't think you're going to come to the maintenance court and say, ek gaan my storie by die hof gaan vertel. Then that day you want to come and tell your whole history. The magistrate sit with a lot of cases every day, not just your case. So please don't think you're going to come to court and badger the court with a whole lot of information. It's unrealistic. A maintenance officer only work with those files in front of him. Now you come with your whole history from 2015 and you bring your whole bag, checkers bag, full of bank statements, thinking that, ag, het hom wys vandag alles wat ek het. They don't have time for it. Prepare before the time, at least a week or two before the time. Call the court, ask the court, listen that you receive a return of service, het hy mannetjie gesign, of weet hulle, does he know that he needs to be at court? And then make sure that you've got a supplementary affidavit that updates that arrear amount. Because if you don't, you are busy sinking your own case in the maintenance court. Then the court is not working for you. And when the court gives judgment and say, I can only work on your March document that says 2,000 arrears, you say, justice system werk ook nie, is almal they are working with him. They are not working with him. They will work with you if you work with the system. And you need to understand that and stop complaining on Facebook that the justice system is not working. The justice system is working if you make it work for yourself. If you understand what is being said over the last 2 years at these dialogues, then you will understand where you're going. But if you do not, then don't go and complain. Or if you want to complain, then you have the right Facebook page to complain. They will listen to you and say, I'm sorry, stem saam die justice system work. Then continue on that train. But you're going to get nowhere. You will get thousands of people that agree with you, justice system don't work. But let us make it work for us. And the only way we're going to make it work for us is if we come to the community dialogues or we go online. Mr. Arthur, why are you laughing? Because that's where you are always here, and you take these handouts. And if the handout is not working for you, don't throw it away. Give it to somebody else that can get some of the information that's in here. Because there's valuable information that explains how the process works to make it easier for all of us. And that is the way we're going to take it further. I've got some more information, but I don't want to go in the Sermon on the Mount. We don't have that time. I will give an opportunity for our MC, and then if there are questions, please come forward. We've got a speaker, but if we put it on, then there's a disturbance for our online viewers. So those of you that have questions, if you can just come and stand over here in front, just to save a little bit of time, then we can quickly answer your questions. But please keep your questions short and asking, and don't come with your whole history from 2015 till now. I can't follow all of it. So if you have a question, you are more than welcome. Bongi, you can come.
Thank you so much, Adv Ruiters. Just a reminder, people are broadcasting.
Sorry.
People broadcasting is available on our www.maintenance website.
I do have a question from one of our online viewers for Advocate Raters. One moment. One second. Okay, so the question is maintenance for major or adult children? Are parents responsible to maintain the child enrolled at university for full-time studies for a second degree?
The question is, in a case where a person is enrolled for full-time studies at a university or another degree, are parents liable for it? Yes, they are. There are case law saying that maintenance do not end at a specific age. It can continue even into your adulthood. There are case law that says specifically, even if they're at university, then you will still pay. In the Z versus Z case, the 23-year-old girl in Port Elizabeth, she was still at UPE when the mother applied for maintenance in that specific case. Ms. Mariette Smith in George in the DWT versus MT case, also her two sons were 19 years old when she applied for it. So in any case where the person is either at university or at any tertiary institution, there is still a duty to maintain that specific case. In the Butcher versus Butcher case that my wife always quote, the lady or the daughter was also at university when they wanted to attach the law books of the respondent that was also incidentally an attorney. So in all of those cases, there is still a duty beyond the age of 18. And as I said, please read the article in the Rebus, the January-February edition, applying for maintenance on behalf of adult children by Natalie Ruiters. And there you will see what she then argue as far as the Z versus Z case, as well as the analysis of Z versus Z and what the Supreme Court of Appeal did. She also quote other cases and then do an analysis of the other case law. So look at that, and there you will get. But short and sweet, yes, there is a liability beyond the age of 18. 18 doesn't become a magical age. In the article, she says it's not a magical age where a child all of a sudden, when he wake up that morning of his 18th birthday, all of a sudden become an adult. Doesn't work like that. There is still a financial need of that adult. Are there more questions?
Are there any more questions for Advocate Ruiters? Please come to the front. Thank you. Yeah, you can also come to the front, please. Lisa. Ms. Liz O'Connor, you can also come. Thank you very much. Anyone else? Okay, you can come to the front as well.
Good morning, everybody. Good morning, Advocate Ruiters, especially to you. In April, the beginning of April, I actually sent you an email regarding a dad who has left his job and now I tried to apply for his provident fund. I've been to the court. I filled in all the papers as you have recommended. I've also contacted the magistrate, the manager that's there. They've just replied, how far is the case? And nobody has come back to me yet. So that is more than a month later now. What's the next? Bellville. Yes. Okay.
You can go ahead.
Thank you.
Ms. Simons, and that's what I said earlier. If you're not going to follow up on your case, then absolutely nothing is going to happen to your case. The maintenance staff is supposed to inform you of every step of what they're doing, that they attach, or whatever the case might be. But unfortunately, in most cases, it doesn't work like that unless you follow up on your own. That's the negative side of the South African law. Hopefully, over the next few months, we will change that persona and that message that's going out there. But Bellville Court was supposed to contact you and tell you that this is how far the investigations are and whatever it is. Please, before you leave, give your details to Ms. Liesel Cornier. She goes to court on the days that she's off or whenever she's got time. Then she puts on our maintenance support group that I am available today. I can assist anyone at Bellville Court. Then she goes and sit with you there, and she knows all the right questions to ask. So please hook up with her on our maintenance support group for our online viewers, and you'll see Ms. Cornier will come up now. Ms. Cornier as well as Ms. Ras, they are our ambassadors that go to some of these courts, not because they don't have any business, but to help people. So this is the giving heart that is amongst us over here. So if there are anyone that needs that assistance, these two ladies have been putting on the group. I've got a few hours available. I will go to you. And Cornier, everybody knows her at Simons. Everybody knows when they hear she's coming, they put the red carpet out there for her. So make use of her, please, and he will assist you to make sure that the questions are being asked. And if the right questions are not asked, there's nothing to stop. You've got my email address, then I will deal with Bellville Court, but we will deal with your case. By August, it will be sorted out. I want you to come back and tell the audience as well as the online people whether your case was sorted out. If not, because the Department of Justice have a system called NOC, the National Operations System, National Operations something. I don't know what the C stand for, but it is something to do with the national operations of how they deal with cases. And within 90 days, they're supposed to sort that case out. I know your case is well beyond 90 days, but give us the details, and yourself, myself, and Miss Arnell Ross will sort it out for you. Okay? Now, I mean, Ms. Liesel, can you want him to see Mr. Arnstein now? Please come.
Morning, everyone, and everybody online. I hate standing in front, and I'd rather stand behind the curtain and do my thing. Unfortunately, I've got cases now running in court. I've got a civil case which is going to be taking place this week. I don't want to say too much about it. Then I've got a Section 31 where a garnish order was involved. I want to know the arrears that are now accruing. Can I add interest on those arrears, even though there were no arrears on the garnish orders arrears? That was the one question. And because it's a criminal case now, sorry, I'm talking about Section 31, the maintenance investigating officer must do investigations, but he can't do investigations if he's not told by a prosecutor to do the investigations. Now, there's no better investigating officer, or there's no better investigator or someone to find out information than the mother. Now, I've got all the information and I've handed it to them on a silver platter. The maintenance investigating officer still told me he can't do anything. He pulled me inside to one of the rooms and he said, I can't do anything about your case if someone doesn't tell me to do these things. So how do I get the prosecutor, who is going to wait a week before the time again, before the court date, how do I get someone to tell them, here's the information, all the details? You can just phone these people and ask them for the information, for subpoenas, for affidavits, etc., etc. How do I get the prosecutor to act and to do a job?
The question is interest on the arrear amount where there's the emolument attachment order. And number two, use it with all the information. How do you get that information to be acted on by the maintenance investigator? I'll start with the last one first. Mr. Eugene Opperman the maintenance investigator can only work on instruction or direction of the maintenance officer. That's why I said that to you. So the best way to deal with it is you give the information to the prosecutor, but don't just give it to the prosecutor, CC the maintenance staff in too. So send an email to, who's your prosecutor, Mr. Bloemfontein? Or Miss Tracy Lewis. Then what you do is you send it to Miss Lewis and you CC the maintenance staff in it. Because at the end of the day, Miss Lewis must give an instruction to the maintenance investigator and tell the maintenance investigator, please investigate this, please get the bank statements for this period, or whatever information you have that needs to be confirmed by the maintenance investigator can be done that way. On the question of interest, in terms of Section 31(1), the Act is clear. You can ask for interest, but the court will only act on it if there's an affidavit that states that you want interest. Under no circumstances will any prosecutor or maintenance officer say, oh, okay, but I think there must be an interest ad. They will never think of that unless you somehow alert them to it, that this case is in mora, in debt for more than 10 days. Therefore, I request the following amount of interest on it. And I always worked on the interest in terms of the small claims court legislation. I spoke to a magistrate the other day, and there is a prescribed rate of interest act And in terms of this interest act, it is supposed to be 10%. And a magistrate told me, no, but why are we using the small claims court interest rate while there is a prescribed rate of interest act that says what the amount is supposed to be. So what I would like you to look at is when you say that you would like to have interest, and you say that in terms of the prescribed rate of interest act, you would like the court to then add that amount of interest to your case and then deal with it. But you'll have to calculate it ourselves. We're not that clever, so please make sure that you calculate it all out, because the last thing a prosecutor dealing with a case, we know acts and sections. You've heard how I quote the sections and all of it, but don't ask me. I was sitting right at the back. My maths teacher, Mr. Barnes, said I was special. I always thought I was really special. Then I found out it's because I don't know calculus that I was so special. Thank you, Mr. Barnes. If you are somewhere out there, you'd like, please tell Mr. Barnes, I know why he said I'm special. It's not because I know calculus, it's because I never knew how to calculate it. So please calculate the prescribed rates of interest. I've got a table. I'll show you how to deal with it. And then we calculate it correctly. We send it to Ms. Lewis. We CC the maintenance staff in. So the day when you go to court and you testify and say, but this is what I want, then the magistrate can't tell you, but no, but there's nothing over here. Make sure in your supplementary affidavit you say that I would like interest to be calculated on the amount that is outstanding. Mr. Answer, can I ask that the lady? Please ask you.
Morning, everyone, once again. I'm sitting with a challenge here. I lost my sister last year, and then she left her daughter into my care. So I decided to remove the child to East London, to my mother. Now the problem is I asked the father to pay for maintenance, to help me, because I can do what I can, because I'm married, I've got my own 2 children. Now the problem is the father only paid 1,000 rand August last year. The girl is 17 years old. He passed matric last year. I've been asking the guy to pay for maintenance up until now. He just ignored my messages. The only time I spoke with him, he was asking for the matric results for the daughter. Now my challenge is I'm about to leave my job because I'm a law graduate. I'm looking for a place for articles. Now, if I leave my job, who's going to take care of that child? Because she is staying with my mom, who is partially blind, who's paying a grant. So my question is, do I apply for maintenance myself, or do I rely on my mother to do it herself? But the problem is she is partially blind. So I want to know, do I apply for maintenance myself, or ask maybe my sister who's staying with the child in the Eastern Cape?
Ms. Mpatani, the Law Commission deals with matters like yours. Thank you for your beautiful heart. I need to say that to you. You've got a beautiful heart. After your sister passed away, it's not your duty to be taking care of your sister's child. But that is what Ubuntu have been about all these years. And that is what Lucas Tandy described in that paragraph. Don't worry. As soon as the Maintenance Act is in operation, you can apply on behalf of her. But because now she's 18, it's a little bit different. So your mother in East London be able to apply for her too. Right now, you will have to show Lucas Tandy why are you applying on behalf of her. Luckily for you, there is what we call a written or verbal agreement where he agreed and already paid into your account for your niece that is now in East London. So what you do is you can still, if there is a maintenance order in place at one of the courts, then you can use that and say, I'm standing in for my deceased sister. Else, if there's no maintenance order in place, you can still apply on behalf of her. The only difference is if she was under the age of 18, then in terms of the Children's Act care include taking care of the child in the sense that you send mother maintenance money to your mum in East London to take care of the child. So it's going to be a little bit tricky. The best I can advise you is let your mum go to this London court and apply then for maintenance. If she's too old, then rather get one of your other family members that are more responsible. Since she's turning 18, she can apply on her own behalf too for maintenance. She is not in any way bound by it. The Law Commission have a beautiful, also another point that is in there that I simply adore. Social workers can now apply on behalf of your niece too. So in a case where your mom is too old, then a social worker can stand in and apply on behalf of her. Just make sure you give as much detail as where he is and all of that. Get a copy of my wife's article, send it to him and say, Papaji, you still have a duty to pay maintenance, even though she is over the age or getting to the age of 18. She's turning 18. Speak to Natalie. She will give you a copy of the article. It's also over there. Just scan that barcode with her face on it, and then you'll be able to get that article. Send it to him. Before you leave, let us get your details and we will assist you. Everything that I'm saying now, we will type out for you and give to you. You cut and paste it and put it on WhatsApp and you send it to him and say, I was at a meeting and this is what the advocate said, so they better deal with it. In the East London, my colleague, Mr. Roland Mkwani, will be more than happy to assist your family over there. I've got these details. I'll put you in contact with him and he will assist you. But thank you for coming. Thank you for your beautiful art. This is what this is about. We tell these stories. We need to know all of these things that's happening. And everybody now knows Ms. Mkwani and what, I'm sorry I'm pronouncing yours, Mpatani. Everybody online is hearing your story, and that's what it's about. We share that information and inculcate one another with that information of what's happening now. Somebody else also have the same problem as you, knowing that actually I can get somebody else, a social worker, to assist me. So we appreciate these type of questions coming forth and dealing with it. I'll get to you now. I'll first give Mr. Arnser before Mr. Arnser hit me. So Mr. Arnser, let's hear your question.
Thank you, sir, Advocate Director. I would like to apologize to you and to everyone else. I'm normally that co-worker that after a meeting, you ask that question that drags the meeting on for another 20 more or so minutes. So my question is basically, does the Maintenance Act speak about any proof or merits where the child is to look at whether a child is truly benefiting from the maintenance? And if so, where in the Act? And if not, why not? Thank you.
Mr. Arnser always have this way of asking all the higher grade questions that is supposed to be going to Mr. Jandar Goliath, but Mr. Goliath is not here, so I'll have to struggle through it. Short and sweet, no, there is no provision that somehow monitor what is happening and whether the funds are being used for where it's supposed to. Why not? I don't know. There isn't anything like that in the Law Commission paper dealing with abuse of maintenance funds. Nowhere does it mention. There is a provision in the Children's Act dealing with parenting plans and the monitoring of parenting plans. Natalie is going to touch a little bit on the monitoring part of it. So there is a way in, if there's a parenting plan that says that the maintenance must be used in a specific way, or for school fees or for school clothing, and any of that is not being done, then you can use the Children's Act for a monitoring order. The Children's Court can make a monitoring order to see whether there's compliance with the provisions of a parenting plan, but there isn't such a thing in the Maintenance Act dealing with monitoring of the maintenance quantum and whether it is being applied for the benefit of the child and in the best interest of the child, the Section 9 best interest of the child. But that will be a good thing to take to the Law Commission. why isn't there any monitoring built in to see that those funds that are being ordered by the court is actually in the best interest, Section 9 best interest of that specific child? So, Mr. Arends, I'm waiting for your the submission, and I will assist if you need my assistance, but the Law Commission and the Justice Portfolio Committee need to know about this, and that we can then deal with it. Stunning questions, please continue asking the questions. We're not going to stop you in any way.
Good morning, everybody. Being a grandmother of 62, only getting a grant, a pension grant. My daughter died a year ago, left me with 2 minors. The other one one will be 18 in November, so yeah, that's okay. But the one of 10 years old, the social workers gave me papers to say that they are put into my care, which is I'm the sole guardian of the children. Her father is alive, not interested in her. I took him to court for maintenance. The prosecutor or maintenance officer said, well, Mrs. Arends, well, he can only give you 500 rand, whereby I see him pass my house every day on his way to the drug house. The little girl also sees him, and one morning he stopped, looked at her, and she told me, oh, I thought my dad is going to give me some moolah. I said, oh, well, that's your father. For now, I'm surviving on the 2,090 rand of pension, the 500 rand of a child grant, which is insufficient. Her brother, who the father also just supported for 1 year, he will be 21 in August. He is providing for his sister. And I don't think that's fair. The father gave me 500 rands in November, 500 rands in December, nothing for January, nothing for February. I threatened, I'm going to court Monday morning, you will be locked up. His mother, who is also a pensioner, saw to it that January's money came. 2 weeks later, February's money came. Up until now, it's almost the end of May. Nothing has come, which means March, April, and now May. The little girl, she's not interested. She doesn't want to see him because he has no interest in her. He doesn't see her at all. The grandparents has, for the last year that the mother has passed on, seen her for 5 times. The father lives across the road with another woman. He doesn't see her, and she says she doesn't want anything to do with him. My question is, can he give his parental rights, write off his parental rights, so that this child has nothing to do with him, or he has nothing to do with this child, and I have complete care about her?
I'm never in favor of termination of parental rights and responsibilities. The Act, the Children's Act, makes provision for the termination of rights, but I'm not in favor of it, because I've seen what they've done over the years whenever a person terminates the father's rights. In your case, it will be different, but in other cases, they will rather ask you, Granny, why did you do that? Because the father said no, the granny said that I mustn't come close to them. So I'm never in favor of termination of rights and responsibilities, unless they are at that age where they understand what it means and tell you, I don't want to have anything to do with. Then you can apply. Then you can apply for the termination of rights but not responsibilities, because if you terminate the responsibilities, that means you don't have a responsibility towards maintenance anymore. But it's difficult to do the one and not the other. So the court will ask you, why are you wanting to terminate the rights in that specific case? I'm glad that you went to the court. that information that you give of all the other detail, that needs to be in a supplementary affidavit where you give all of that information pertaining to your specific case. What means does he have and how he is supporting one and not supporting the other. The adult that is over the age of 18 can still be supported in that same way. If you struggle at the maintenance courts, please let me know and I will then intervene. Mr. Arendse knows, he's also Mr. Arendse like you, Lucian Arendse, he knows the provisions. If you have any problems with it, let me know and I will then assist you in that specific case. Okay. Valdila, can we just hold it for a little bit so that the other speakers can also speak and then we will get to it. Um, do you have another question? Oh, okay. Faldila, let's give one more person a question online, and then, but I will give you an opportunity after Laurie spoke. Then we'll get an opportunity. Sure. Yeah. Yeah. Okay. Do you want to come and say it here?
Yes, yeah.
Okay, I'm not going to punt mediation, but I'm going to try anyway. Section 22 of the Children's Act, you can apply for shared parental rights and responsibilities, and then there's agreement that we draft for the Children's Court. But you can start it with a Form 2 application at the Children's Court, should you not opt for mediation.
Yeah, thank you very much for your excellent questions, and we are all learning. One more question for you, Advocate Deon Ruiters, from our online viewer, one of the online viewers. How to deal with respondent whose assets and funds are abroad?
It's more difficult when the person is abroad. In July, we're going to have a special guest over here. It is in your notes, and I've arranged with him to fly down free of charge. We're not paying a cent for him to come down. Mr. Mervyn van Meulen will join us, and we will be dealing with international maintenance, including the REMO legislation. But I asked Mr. van Meulen to deal with a different section of international travel, not having consent to travel, and all of the other international law. I will just deal with my little bit of maintenance that I know. I brought a giant over here. You're going to see when he's here. Mr. Arns, you need to book in advance because it's going to be full. Mr. Mervyn van Meulen has got a group called Think Legal Family Law. Please, if you can get on that group, you will enjoy seeing the information that is being shared on that group. But Mr. van Meulen will come and address international law. If assets are overseas, then what you will do is, if your matters in this country, then the REMO legislation is applicable. And in terms of the Reciprocal Enforcement of Maintenance Orders Act, REMO Act, you can then apply for the attachment in the other country, and that is in terms of the REMO Act 80 of 1963. Section 8 of the Act says that we can attach in the other country. I've done a few. We've got 32 of those matters in the Western Cape that I'm dealing with. So the online viewer that posed that question, please send me the details of your case, and then I will explain to you the REMO procedure. If not, come to or book on Quicket your July slot, and you will get the information first and from Mr. Mervyn van Meulen. I will present the REMO legislation, the two REMO Acts. There are two of them. The one is the REMO Act 80 of 1963, if you want to read up on it. The other one is the REMO Africa Act 6 of 1989. Those two pieces of legislation I will go to in detail, where a respondent is in a different country and you would like to get your rights enforced in the other country. There's a lot of prerequisites. The country must have an international treaty or a working agreement between the countries. If not, then you can't use the REMO legislation, but you can also use the UN Convention on the Rights of the Child, Section 26, Article 26 of the UN Convention on the Rights of the Child deals with it. I will explain all of those different legislation and why some are going to the ministry and why some are going to the Director General's office. It's a lot of intricacies. Luckily, it's going to be recorded. You'll have to listen to it again to understand all of the stuff. But Mr. Mervyn Vermeulen is a Britannica of information. You need to be here in July to hear that man speak. When I sit and listen to him, my mouth is jaws hanging open. I have to close it every now and then when he starts speaking. But a wealth of information. We will give him an hour to address us, and he will give us all the information. But short and sweet, Emo Act 80 of 1963 deals with it. We can attach. The attachment process is a little bit difficult to go through. The online viewer that posed the question, we will then make sure that give me your email address or give it to our MC, and I will make contact with you on Monday, and I will give you that information. But the other viewers or the persons that are in, the delegates that are here, please book in advance on Quicket for the July session with Mervyn Vermeulen. You will not be disappointed. That's a promise I make. Thank you.
Thank you so much, Prosecutor Ruiters. Just a reminder that we actually have a WhatsApp group, hey? So please do join the WhatsApp group because that's where we actually give more practical, hands-on advice. You're welcome to post your questions and your story, and we have mothers and some legal practitioners there who are always willing to assist. So where do we find the link? Go on our website, www.childmaintenance.org.za. It is also on the handout, and the WhatsApp link is there. Just download it and then obviously join. And there's something that Advocate Ruiters mentioned when he was speaking about paper 157, and I was quite challenged. He said, let us make the justice system work. And I thought, wow, what are you doing today to make the justice system work for you, for your case, and for those around you? What are you contributing towards making the justice system work for your own case and for those mothers around you? And I think that's what we are actually saying in the WhatsApp group, where we're not waiting. We're not waiting for one day when things change. We are creating the change that we want to see in the justice system. So we've just slightly changed the program, ladies and gentlemen. We're going to have our session on mediation after break, but for now, I'm going to welcome our next speaker, who's going to talk about how to request interim maintenance orders after the first appearance at maintenance courts. And then we're going to have a quick break after that, and then come back and have our interactive session. I would like to welcome our very own ambassador, Ms. Luna Russ. Let's give her a warm hand of applause, please.
Good morning, everyone. Before I start my presentation, I didn't get your surname, and I would just like to say I'm really sorry about the huge loss that you experienced last year. Thank you so much, everyone. Welcome. Thank you for attending, and thank you for the online people attending as well today. Advocate Ruiters asked me to discuss interim maintenance. So I'm just quickly going to go to the section in the Act, read the whole section, and then we're going to go into more detail. So Section 10.6 of the Maintenance Act regarding interim maintenance says the following. A maintenance court shall conclude maintenance inquiries as speedily as possible and shall, not may, shall ensure that postponements are limited in number and in duration. B. A maintenance court may, where a maintenance order has not been made and a postponement of the inquiry is necessary, and if the court is satisfied that there are sufficient grounds prior to such postponement indicating that one of the parties is legally liable to maintain a person or persons, and the next very important prescription, undue hardship may be suffered by the person or persons to be maintained as a result of the postponement. Subject to paragraph C, make an interim maintenance order which the maintenance court may make under section 16(1)(a). Now I'm going to break it up a bit in small pieces. Let's go back to the first part. It says a maintenance court shall conclude maintenance inquiries as speedily as possible and shall ensure that postponements are limited in number and in duration. Speedily as possible. So the question that I think all of us are asking, why are cases remanded for months on end? We need to inform Parliament that our cases are remanded for months, despite the legislative provision that maintenance cases should be finalised as soon as possible. Advocate Ruiters spoke about the NOC, and forgive me, I'm also not sure what it stands for, but I know they aim to finalise cases within 90 days. I don't know anyone whose case has been finalised within those 90 days. Next point, shall ensure, and that's a very important point, the shall, I'll get back to that now, shall ensure that postponements are limited in number and in duration. Now, I'm a layperson myself, but I have been taught that may and shall within the legal context mean different things. So in law, if it says may, it's exactly what it means. It says it may. So the court has a discretion. But when in law it says shall, it means the court needs to abide by that. That's what shall means in my opinion. That's what I've been taught in the legal prescription. So the reality is South African maintenance courts remand cases between 5 and 10 times and for long durations. But maintenance courts do not want to pay section 11(1) of subsistence and travel allowance. We're going to have a discussion about that allowance at a different stage, not today, but I just wanted to mention that as well. Next point is the maintenance court may, where a maintenance order has not been made, and this is very important. Interim maintenance will only be granted when there is no maintenance order in place yet. So, like I said, only when no court order was made. And then the next point, the South African Law Commission is considering interim relief orders where maintenance order is in place, but the case takes a long time to finalise. And you can refer to Chapter 9 of the South African Law Commission Paper 157, as Advocate Ruiters discussed earlier. The South African Law Commission, page 137, if you can get your hands on that, I'm sure we can share that on our website at www.childmaintenance.org.za. Proposed maintenance courts can make an order for an automatic adjustment of the amount claimed, where such amount, due to the delay in the civil execution process, has changed since the application was made because of maintenance payments received or not. Advocate Reiters touched on that earlier as well. Currently, now an interim order can be claimed for on a J107. That's just the form, that's just what the form is called. Increase applications to accommodate urgent expenses like moving to a new area and deposit is required. And then no interim relief possible in cases of arrears. So a J470, what we discussed earlier, Advocate Reiters, it's the complaint of arrears. No interim relief possible at this stage. Then the next point, if there are sufficient grounds prior to such postponement indicating that one of the parties is legally liable to maintain a person or persons. And so how will sufficient grounds be established? By means of evidence in an affidavit or on a form J101 or J107 that he or she is the biological father or mother of the child. I want to quickly stand still at this point. I think it was 2 months ago that I mentioned about the form, the confirmation of paternity form, which is extremely important, and that a lot of people sometimes forget to complete it in front of the maintenance officer. So when you are in the maintenance officer's office for your Section 6 inquiry, which is the first, it's an informal inquiry, there is a form that can be completed while the applicant as well as the respondent sits in front of the maintenance officer. And that's called the paternity form, the confirmation of the paternity form. Both parents sign it so that there will be no issues going forward. Because if that's not signed at the start of the process, you may find yourself months afterwards when said respondent needs to pay whatever amount, all of a sudden he's not the father anymore. Then he requests DNA test, which obviously is his right to do, but it could have been avoided should that specific form being completed on day one. So sorry, I'm just standing still at that. Another alternative is under oath evidence instead of the affidavit, but courts do not have the time to conduct trials and to have evidence on record. So once again, and as Advocate Reiters always states, take ownership of your own case. If you don't know, please ask questions, but please understand that it is still your own case. You need to take ownership of it. By filing your affidavit or your supplementary affidavit that speaks on your behalf when you are not at court, and a maintenance officer or maintenance magistrate peruse your file. I understand it might be difficult for some people to compile an affidavit. If you have never done one, it's completely understandable if you have no idea how to complete it. But as Bongi said before, and as Advocate Reiters said before, on our website, and I'm going to mention it once again, it's www.childmaintenance.org.za, you will find an abundance of affidavits. It's under the public tab. You just click on there. And obviously on the affidavit, you just change whatever your story is. So the basics will be there. The framework will be there. Your story will be different. You just change the affidavit so that it fits your own story. Remember, your maintenance file with affidavits can talk on your behalf when you are not there and the maintenance officer prepare the maintenance files for court. Also remember that the maintenance magistrate can peruse your maintenance file before the actual trial and acquaint himself or herself with the content of your file. It is advantageous to have your story in an affidavit format in your maintenance file. So it gives the court your story. It's on affidavit already, and it gives the court your story. As Advocate Reuters mentioned, the court can only handle a certain amount of cases per day. They will not allow long, tedious processes. So if everything is in an affidavit, your whole story with attached proof, obviously please attach proof as well, then whenever the maintenance officer or the maintenance magistrate peruse your file, your story is there already. So you don't need to worry, will the court... So I don't know if anyone heard about the expression when a magistrate says, but it's not before the court. And that's exactly what they mean with that. They will not allow people to stand there for hours on end explaining their story, how heartbreaking it is, and I understand that. Of course you need maintenance, but that's why you have affidavits. Founding affidavit at first, and afterwards, if there's any other changes to your story, supplementary affidavits can be attached as well. Now we get to the section of undue hardship may be suffered by the person or persons to be maintained as a result of the postponement. How will you show undue hardship? Once again, by filing an affidavit in which you explain to the maintenance court how the non-compliance to parental obligations is affecting your living, your employment situation, and your entire family life. For example, you have to borrow money and pay interest on loans. Another example, you have to stay out of work to attend court, which can lead you to being dismissed because of staying out of work too often when you needed to be at work. And your new partner or husband can get frustrated due to you spending lots of time preparing for court or coming home depressed or unhappy from court, which obviously happens. And your child, undue hardship. How can a child survive even a day without food? Even 2 days, a week? That's exactly what you put down in your affidavit. My child will not survive if interim maintenance is not granted by this court. Section C says make an interim maintenance order which the maintenance court may make under section 16(1)(a). What is important is there is no specific form for an interim maintenance order yet. Some courts use the J214, and apologies for the terminology, that's just what the form is called, consent order, and they just scratch out the words consent and they replace it with the words interim. If you read the words on the J214, which is the consent order, it actually says in terms of section 17, and further down the page, it says A, written consent in terms of section 17(1), while the interim maintenance order is actually in terms of section 10(6) and not section 17. So this is a problem. It might be a technicality, but it can cause problems at a section 31(1) where criminal proceedings may take place and then it's on the wrong form. The way forward is, as I said before, take control of your own maintenance case. Insist on interim maintenance in terms of section 10(6) if the respondent do not have all his documents at court. How many times have you heard you go to court, it's court date, you arrive at court, you're there, you've got all your documentation in place. Oh no, sorry, he doesn't have his payslips. Oh no, sorry, he doesn't have his income statement. Ask the maintenance officer, has the person been served properly, summoned? Ask to see that, and as Advocate Reuters said, that you should have done at least a week before the court date, not on the date that you get to court. You should do that way before to make sure that the respondent was properly served. But when that respondent rocks up there on the day and he doesn't have his documentation, insist on asking for interim maintenance because he has been served. If the maintenance officer refuses a Section 10.6 interim maintenance order, ask why. And ask them to place that on record. Insist on seeing a magistrate and again bring your request for interim maintenance. Some of them will tell you you're not allowed to see someone now. You do not leave that court until you see someone, until you see that maintenance magistrate. You have a date to be there. You do not leave court until you've asked for an interim maintenance order. If the magistrate refuses a Section 10.6, you ask why. Politely. Please remember that. This is very important. It's always your worship. Please remember, politely ask. Your worship, if I may ask, what is your reasons? He or she will state the reasons. Ask them, please, to put it on record. I'll get to the red lights now. But it should always be on record, because if it's not on record, you cannot appeal that decision in the future. Oh, that's what it says now. Sorry. So it says, ask the magistrate to note that refusal of a request for interim maintenance on the court record, and then the reason why. It's to take that magistrate's decision on appeal in terms of Section 25 of the Maintenance Act. You can only take a matter on appeal if it was before a magistrate, not when it is in the maintenance officer's office when that decision was made. Therefore, we insist on seeing a magistrate. If the maintenance officer refuses to take you to the magistrate, then file a complaint immediately at the court manager or the area court manager. We did have a discussion about the complaints process either a month or 2 months ago, but that will also be on the website www.childmaintenance.org.za. That is the formal complaint process. If you do not follow that, nothing will be done. Nothing, because no one will know about your complaint because it's not formal. If the court manager do not act immediately, file a complaint at servicedelivery@justice.gov.za. When you get to your appeal, so for instance, this is when the magistrate refuses to give you your interim maintenance order. So when you get to your appeal against the refusal of the maintenance order, you ask that your request be recorded. What we mean with that is the red light must be on in court. It does happen that people do not want to switch on the red light because then they know it's recorded, but you politely insist that that lights be switched on. That's the only way that you know that those proceedings are recorded. Ask the magistrate to note. You ask for a Section 10.6 interim maintenance order on the court papers in your maintenance file. You then go to the maintenance clerk and ask the clerk to assist you with the appeal process. You should request the magistrate to give his or her reasons, like I said before, in writing. You file a request for reasons. The maintenance officer and maintenance clerk will assist you with this. Then you file your notice of appeal by stating the reasons why you want an appeal and indicating where the magistrate was wrong in not hearing your request for interim maintenance. As I said, your examples will be on our website. I want to thank you for your time and enjoy the rest of your day.
Thank you so much, Ms. Rinaldas. We're going to take a short break now and we will come back at 12. But before we do that, our very own Mrs. Annika Greyvenstein. It's your birthday today? It's your birthday today? Yes. So, we would like to just take a moment and sing for her, please. Happy birthday to you. Happy birthday to you. Mika. Happy birthday to you. Hip, hip, hooray! Thank you so much. Happy birthday. And we're going to take a break now and we will be back at 12 o'clock. Again, thank you to the online viewers. Thank you so much for taking the time to join us today. And thanks, Ms. Natalie Raters, for making sure that our online viewers are taken care of. And we will see you back at 12. Thank you very much.
the maintenance system. It could not be fulfilled through the justice system and the maintenance court system. I literally went onto the Cape Flats and did the following. Anyone out there with maintenance problems? I was completely overwhelmed by the reaction. We had set up a call center in the early days, and in a short space of time, we dealt with more than 10,000 cases of maintenance. Mostly at that point in time, cases of arrear maintenance. We started out helping people to collect their arrears maintenance. We would make phone calls and speak to the fathers, mostly fathers, and eventually they started participating. They started paying their arrears maintenance, and they then wanted to continue to make use of our services, but to help them to establish contact with their children. They would say to you, I can't pay for something that I don't see. You don't buy a movie ticket and then you don't go and watch the movie. If I pay the ticket, I would like to see my child. So that's where the mediation started out. But we were 80% successful in what we were doing at that point in time. And that was doing way better than we had been doing at the maintenance courts, where I worked previously. So we started mediating then 16 years ago, and we were taken down this road of mediation, helping people to resolve their family disputes through mediation. And that was a very interesting ride up until now, really enjoying what we are doing. And it's so great to have someone working with you. My wife is still working with me today. She's a great, great motivator. She has worked on an app for almost a year, no longer than a year. And that app is alive, it's viral, and it's one way to deal with maintenance matters also. But it's basically an electronic parenting plan. People find it difficult to talk to one another, but if you have this little thing in your hand, it's easier between you, and there's great benefits to that as well. Okay, and then obviously before that, I started dealing with maintenance cases 36 years ago. When I studied law after I started working, and I worked at the magistrate's office after I passed my first year of my Bachelor of Laws. I was sent to the maintenance desk, the maintenance office, to help people in dealing with their maintenance disputes. And while I was standing there one day, it just crossed my mind, Laurie, one day you're going to do this for a living. And immediately I discarded that because I wanted to be a successful advocate dealing with big criminal cases, etc., etc. Guess what? Life happened to me, and here I am today. Really enjoying dealing with family disputes, maintenance disputes, etc. And I even have someone helping me with that. Okay, so it's all about conflict. Now, who of you enjoy dealing with conflict? We don't. Okay? I've worked as a prosecutor for many years, just like Adv Ruiters. And even after working as a public prosecutor, I can still tell you today, I don't enjoy dealing with conflict. But the mediation process is a beautiful thing. It gives us a process, and if we follow the process, it's so much easier to deal with conflict. Okay, so you will see on this slide the conflict path. Right on top, we have the manifestations of conflict. That's almost too late, but this is where we get involved most of the time. In the courts, as mediators, things have escalated way beyond what we imagined. And it's the reason for that is we do not talk to one another often enough to deal with the causes of the conflict first. If it's possible to, when you identify the problem where there's a cause, start dealing with that, then it's much easier to deal with the conflict if there are some aggravating factors. It's possible to moderate the conflict before there's an explosion right on top, where you can see the manifestations of conflict. Now, as a mediator, working as a mediator for more than 16 years, this is what we do on a regular basis. So there are types of conflict. First of all, intrapersonal conflict. This is the conflict that we carry within ourselves. If you're in a relationship and you contemplate, shall I leave? Shall I not leave? What about the children? What will the community say? What will the church say? What will my parents say? That's the inner conflict. And all of us do have this inner conflict. It's often difficult to choose between right and wrong, between right and right, because of this inner conflict. The second one is the interpersonal conflict, which is between two individuals. This could be between husband and wife, between partners, between colleagues at work. Then intra-group conflict, the type of conflict that happens among individuals within a family or within a team. Now, family, in the family context, this could be, he still goes home and he enjoys mom's meals. He doesn't come home to enjoy the meal that his wife is cooking. So a source of conflict. And then intergroup conflict takes place when conflict arises among different families and teams. This could be after divorce or separation. Now there are two groups opposing one another. Have you realized if you move on in life, you go through the divorce or you separate, then all of a sudden his family is not your family any longer. And there's an escalation of conflict once again. So if we talk about relationships, breakups, divorces, there are 6 stations of divorce and separation. The first one is the emotional divorce. For some reason, people think there's only a legal divorce. That thing that happens in court, that's the divorce. No, the divorce is much more complicated than just that legal exercise that the people go through. There's an emotional divorce that takes place. Distance between the parties. They stop sharing information with one another. Very important information. And then there's the legal divorce. That can be the ugly one, especially if it's not a mediated divorce. Things can get ugly. We have learned in our practice that family matters should rather not go on to litigation. They should rather be mediated. The chances are much better for the family to survive. Even after the divorce, you can still be family. And your children is not just your children, it's also your ex's children. and you will always be related to your ex, whether you like it or not. Yes. The third one is the economic divorce. There are two households now, and there's more month than money, and we have to get through that, and that's where we meet each other in the maintenance court. But if we can talk about that, it's much easier. And then it's about the children, the co-parental divorce. What decisions will you be making about the children? Do you have a parenting plan? If you do have one, hopefully you had the services of a good mediator to assist you through that. The fifth one is the community divorce. Shall I tell my parents now? Shall I wait until the paperwork is done? Can I tell the people at church? What about the neighbors? And then the last one there is the physic divorce that takes place. So we take note of all of that. When we help people with their separations, their family breakups and divorces, we are well aware of the fact that the parties, when they separate, they go through a similar process of grieving. The author, Helen Kubler-Ross, has written the book on the 5 stages of grief. Now, in every separation, in every divorce, we also see this. Number one, there's denial. It's not happening to me. No, it's definitely not happening to me. Second stage, anger and resentment. How can he do this to me? How could he? The third stage, dealing with the bargaining. I will stay. I will even change. Please don't go away. Please don't leave me. If I do this, will you please stay with me? Etc. The fourth one is depression, where you realize this is really happening to me. I will have to move forward on my own. And it's difficult for people who've been in a relationship for quite a while. You know, they started out, they dreamed about life, they dreamed about having a family, dreamed about their children, even where they want to live, where they will retire one day, the little wooden cottage at the seaside, etc., and then divorce is there, or the separation is there. And the carpet is completely pulled away from them, and they don't know where to go. I've dealt with cases over the years where I ask the simple question, so where do we go from here? What is it that you want from this mediation session today? And they cannot tell you. It's impossible to tell you what they want, because they have to move forward. And because they've been dreaming about a whole life with their partner, it's extremely difficult, and they can't tell you. So, as mediators, we do not rush the process. We help parties to work through that, even if it takes time. Now, I don't want clients where they come to my office every week or every second week, and I don't have a couch in my office. So, as a mediator, I work to get them out of my offices, get them settled and move on. But each case is different, and we have to deal with the cases at the pace that the parties set. Often, when one party has made the decision, the other party is not ready to deal with it. Okay? So it could have taken the plaintiff or the applicant or the one who made the decision to move out. It could have taken that person some years to get to that point. And she has made a decision. But once the sheriff knocks on his door to deliver the summons, he realized this is final, and this is not what he wants. Okay? And this is sometimes when mediation is confused with a reconciliation process. Mediation is not a reconciliation process. We're not there to divorce people, but if there's a chance that they can be and can stay together, then obviously we will help them to stay together. Okay, and the last one is then acceptance. In many cases, people do not ever get to the point of acceptance. And we can move to the next slide. Thank you, Anneke. Who's that? Okay. When did she look like that? Is she still looking like that? Maybe, I don't know. Okay, but that was in the 1980s and the 1990s. Isn't that so? So I was in my office one day and I had an appointment with someone who wanted to see me for a pre-mediation session. And a person looking like that walked into my office. Wow. I was about to ask her, are you busy with a film shoot somewhere? No, this was real. This was her. And she said to me, listen, Laurie, I don't want to waste time. I've been divorced for almost 18 years now. I'm happily divorced. I have a son. He's going to varsity next year. We want his money. We don't want his love. I've warned my son against him. Okay? So I just want to make sure that there will be money for him to go to varsity next year. I said, whoa, let's just stop here. Your ex, where does he live? No, we live in the same town, but he's remarried and he's got younger children, etc., etc. And you? No, I'm working for myself for quite a long time. I take care of myself. The father is paying maintenance, but we need some more soon. And I realized that she got stuck. Where did she got stuck? If we go to the previous slide. Where did she got stuck?
Anger, resentment.
Anger and even depression, maybe. Okay? She didn't move on. Now, I knew that I was not going to be her mediator. I asked her, who's your hairdresser? What? Who's your hairdresser? I don't have one. I can see it. Where do you buy your dresses from? Well, I haven't bought dresses in quite a long time now. I can see that. And she was just looking at me. I said to her, listen, ma'am, I'm going to help you to get out of this mess. Really? Yes. What does your ex do over weekends? Has he got any hobbies? Well, he's cycling over weekends. And your son? Has he got a bicycle? No. I said to her, you better get your son a bicycle. Yeah? Well, I want you to tell your son to start cycling with his father over weekends. And then, after a week or 3, they must start talking about university. She phoned me back 3 months later. She said to me, I'm going to send you a picture now. This is the new me. The hair was shaven off, beautifully dressed. She phoned me. She said to me, Laurie, so by the way, I don't need your services any longer. Really? What happened? No. I bought the bicycle. his daddy's paying for his studies next year. Okay? Was that mediation? No, it was not. What was it? No, it was not the hairdresser. Okay? Luckily, she didn't leave angry. She made a point of taking care of herself. Oh, yes, and she also said to me, Laurie, I'm working for myself now. I used to take care of elderly people. That's where I got the dresses from when they passed on. But I've started my own business. I'm training younger people to take care of elderly people. I've got my own business now. She moved on completely. And I'm sure if I phoned, that was 3 years ago. If I phone her today, she's probably married now. She moved on, or she's happily living with someone. Okay, that was not mediation. So I don't want mediators to go there. This is not a mediation lesson, eh? There are, sorry, the next slide, Anneke. There are 3 approaches to dispute resolution. As mediators, we mediate in the shadow of the law. But the first approach is known as the power-based approach, which is primitive. You know, a couple of centuries ago, if you had a problem with someone, you will just go and take back or take revenge. But we've moved on as a society. Okay? Unfortunately, the law sometimes finds itself here. It's a power-based approach to litigate. And it's ugly and it's nasty. How would you feel if the sheriff knocks on your door and delivers a document and it's your ex and you've never had the opportunity to speak to him or her about it? Not good. Okay? Then the next one is positional bargaining. This is more acceptable. You advertise your car in the smalls. I want 100,000 rand for my car. You get a phone call. The guy says, I've seen your ad. Can I offer you 80? And then you say, no, let's split somewhere in the middle. And you agree on selling it for 90,000. Okay, that's positional bargaining. We sometimes see that when we deal with maintenance cases, people bargain. Okay? And then the preferred approach is interest-based. Okay, let's move on. Let's take a quick look at litigation first. Litigation is the process of going to court to argue your case. The case could be criminal, in which the state argues that a citizen violated the law, or civil, in which 2 citizens or businesses argue against each other. Litigation is an adversarial process which relies on the court system, where a judge or a magistrate determines a legal question or matter. Okay, the next slide, please. This is by default, we start with litigation. If we have a problem, we run to the police, or we run to the courts, or to the attorney, and we start out with the process which is most expensive, and that's going to take the longest. We shouldn't do that. The next slide, please. Okay, so alternative dispute resolution is where we should be going. And we're going to turn that other slide around, but before we go there, the next slide, please, Anneke. Let's take a look at alternative dispute resolution. ADR is the acronym. It's divided, Anneke, the next slide, please. It's divided between non-binding and binding processes, alternative dispute resolution. Okay? So non-binding means that there's no one making any decisions on your behalf. And the binding processes of alternative dispute resolution means that someone is going to make a decision on your behalf. Do you like it when other people decide for you? You don't. Why not? Because you want to be in control. Okay? And if other people makes decisions for you, you've lost your control. You're not empowered any longer. Okay? Examples of alternative dispute resolution are arbitration, facilitation, parenting coordination, and plea bargaining in criminal matters. The non-binding processes, that's where we will find mediation, but there's a form of arbitration, also known as refereeing, non-binding arbitration. In other words, I can mediate a whole divorce, and when they get to the maintenance part, they get stuck. They've settled the rest. Now I can say to them, I know someone who knows a lot about maintenance. Would you be willing to participate in a non-binding process of arbitration where that person will listen to both of you and he's going to make a decision that will probably be a reflection of what's going to happen in court if you do decide to take this matter on trial? I've settled some of the cases in that way. Collaborative law is where two attorneys decide that they will sign an agreement with their parties, that they will only remain involved in this particular case if they manage to move the parties to a settlement. But if the parties do not settle, they must withdraw from the process. They cannot take this case on trial now. Okay, that's a different approach. Negotiation is something that we know best. If you buy a car, if you buy a house, you negotiate with someone. So negotiation is always part of the mediation process as well. And mediation, we're going to take a closer look at that soon. Conciliation is when you have an expert. I see myself as a person knowing a little bit more about maintenance than other lawyers. The conciliator can sit down and make suggestions to the parties and say, I suggest this is the way that you follow in this particular case, and move them to a settlement quicker. Restorative justice, we see that in criminal matters. Not all criminal matters have to go through all the formal processes. And then there is peacemaking. I think there are some peacemakers around here. You work in the communities and you help people in the community to settle their disputes in an informal way, etc. And then there's dialogue. Annika, the next slide, please. Dialogue is something that I've learned after I've been mediating for quite a while. You know, when I moved from the far right, which is litigation, to mediation, which is somewhere in the middle here, I said to myself, wow, once people start talking to one another, we see justice happening. Okay? And I've done that for a number of years. And then I was introduced to the process of dialogue. It's about listening. It's about hearing the other person. Do not interrupt. Listen carefully. And then even repeat what you've heard and ask the other person, is this what you have said? Yes, it is. And then the aggrieved person says, wow, she has really heard me. That's dialogue. Okay? Now, the next, no, before we move to the next slide, Anneke, let me just go through the motions here. So that's dialogue. The lady that walked into my office, there was a dialogue between me and her. And because of that dialogue, she heard what I was saying. She was thinking about that. She went back home. It was maybe a week or two, and then she changed her life. We don't have to send everyone to the attorney or to court to have their problem settled. Okay. We must learn to dialogue with one another. Okay. Let's sit down and talk about this. This is something that we got from the African culture, but we're missing out on that. You know, there are some communities in South Africa who will not run to the courts if they have a problem. They will get together on a weekly basis to talk about the problem until it is resolved. Full stop. Okay? Why do we run to the courts all the time? Is it because of something that Jan brought to Cape Town some years ago? Yeah? Okay. Let's give him, ons gee hom die skuld. Ons gee vir Jan al die skuld. Okay, the next process is peacemaking. You need someone to come in between. It could be your pastor. It could be the parents. They can start talking to one another. He will listen to my father, but he will not listen to me, kind of thing. There's a peacemaker. And then conciliation, the person with the expert knowledge in a particular field, onto mediation, and we're going to talk about that soon. Then arbitration, and then litigation as a last choice. Okay, you enjoy that. Anneke, can we please move to the next slide? Now, 3 years ago, we at the Social Justice Foundation decided that dialogue is so important. Once a year, we have a program running around dialogue. It's still young, it's still small, it's still not throughout South Africa, but this is what we do. We're making people, we're bringing it into their living spaces. We sit around tables, we connect via Zoom and the other platforms, and we talk about things. And we learn to listen. That's what dialogue is about, is to really hear what people say. Okay. So where does mediation fit into the bigger picture? The South African law is divided into private law, public law, and the formal law. 3 categories. On the left-hand side, you will see the private law. This is where you take your private matters to the civil courts. There's a whole list of the different sections of the law. And on the right-hand side, we have the criminal law and public law, constitutional law rather, under public law. The third category, we need a civil process to take civil matters to court. We need a criminal process to take criminal matters to court. And then, for both of them, you need the law of evidence to be able to prove your case in a court of law. So where does mediation fit in? Right in the middle. Why? It's possible to resolve most disputes through mediation. Not all of them, but most of them. Okay? Some cases are not appropriate for mediation. And we're talking about domestic violence matters. The serious cases, you cannot mediate those. They must go to court. Okay? It would be unethical to try and mediate some of those cases. Will you try and mediate a case where a child has been molested? No. Will you try and mediate a rape matter? No. Okay? Those cases must go to court. Full stop. They cannot be mediated. But mediation is also a process. But it's not a formal process. It's an informal process that is structured. Okay. Annika, the next slide, please. Let's take a quick look at the definition for private mediation. So mediation is basically divided into two categories. We have private mediation and we have statutory mediation. Private mediation has been going on for quite a while. Statutory mediation is new. An example of that is the court annexed mediation with the court annexed mediation rules. Lately, it's been referred to as court-connected mediation. And also, if you go to the CCMA, that's also an example of statutory mediation. So you have a set of rules, and you must follow the set of rules. You cannot go outside of that. There's more freedom in private mediation. Okay. The next slide, please. The orange story. Do you know the orange story? So, one early morning, Dad heard his two daughters arguing in the kitchen, and he rushed to the kitchen, and they were fighting over one orange. And he ran for what? What do we do as parents? Now you must share. What do? We want to cut that in two. And they said, no, you can't cut the orange in two. Why? And he asked the question, but why do you need the orange? And the eldest one said, Dad, it's Mom's birthday today. I'm baking an orange cake and I need the grated peel of a full orange. Okay. And then to the younger daughter, why do you need the orange? And she said, but Mom is also fluish. I have a recipe that needs the juice of a full orange. Now, by asking that, he was able to give both of them 100% of what they wanted. Okay? That's real mediation. Okay? We create win-win solutions. If they had gone to a court of law, which would have taken very long to get to the answers, the judge would have said, you're the liar, I don't believe your story, I believe you, I'm giving you the full orange, and we have a winner and a loser. But in the end, both of them are losers. That's litigation. Okay. The next slide. The mediation process is an informal process. But there are some formalities. There are three formalities in every not in every mediation, in most mediations. There's a mediation agreement. This is where the parties decide beforehand. If we have difficulties one day, we will not run to court. We will opt for mediation first. Okay? The second one is the agreement to mediate. Now, this is when they've already run into trouble and they decide to go to a mediator, and the mediator says, I'm going to sign with you. I'm also a party to this. We are going to sign an agreement to mediate. Okay? It's very, very important to sign that document. If you don't sign that document as a mediator, the chances are good that they can sue you at the end of the day, and you won't get out of that easily. Okay. The third one is right at the end of the mediation. You've mediated and now they've settled. Then you help the parties to sign the settlement agreement. Annika, can we please move on to the next? So, what happens in mediation? Imagine the inner circle is your mediation room. The mediator is in control of the 3 P's of mediation. The first one, the people who participate in the mediation, in other words, the parties. The mediator is in control of the process. He must take control of the process. If he does not take control of the process, someone else will, and it will be a mess. And the third P represents the problem that they bring to the table. Now that happens inside of the mediation room. And you will see the arrows go in one direction. And if the mediator focuses on the 3 P's, there should be, the chances are 95% that there will be a positive outcome. Okay, but there's also an outer circle where you can see the arrows going in another direction. Wow. So there's confusion there. There's a world outside of this mediation room, and there are people there. There are other processes going on, and there are more problems. And that's where the mediator is not in control. The people out there make decisions and influence the parties against the mediation. The other problems, the shortage of money, illnesses, addictions, etc., etc. Sorry, yeah, that's a problem. Other processes going on, the legal process, and so on. Other problems like addictions and so on, where the mediator is not in charge. Okay. With people, we often find that lawyers, psychologists, social workers, pastors, colleagues, friends, family try to influence the parties who participate in the mediation process. Okay, let's move on. Anneke and myself drove to a farm in the northern parts of KZN over a weekend to mediate a family dispute. Mom and dad had 2 farms and they had 2 children, and they gave each child a farm that must stay in the family when they, it must stay in the family as part of their will. So the brother and sister lived next door to each other for many, many years, and they stopped talking to one another for more than 20 years. And the sister was in her 70s, and she wanted to retire, but that would not be on the farm. And the brother knew that he was entitled to this farm because she did not have any children to pass the farm on to. So she heard that the brother went to an attorney in town, and they've already made contact with an advocate, and that they would issue summons or start with an action soon. And then she phoned me. She said to me, "Laurie, please help me. I don't want to go to court. Is there a way that we can settle this? I heard you on the radio speaking once, and I'm sure that mediation can maybe help." So Anneke and I were there that day. When we stopped there at the house of the sister, we could see the house of the brother on the farm next door. That was about 50 meters away. Can you believe it? They were neighbors and family, and they have not been talking to one another for more than 20 years. So I had a side meeting. After the opening, we had side meetings with both parties. And I asked the brother, "So what do you need to get out of this mediation? And he told me. And then in the next side meeting, I asked her, what do you need to get out of this? And she told me. Guess what? They wanted exactly the same thing. Exactly. She wanted to retire, but she wanted some money to go and retire somewhere close to the beach. Okay? He had already saved the money to pay her out, but they could not say it to one another. People stop talking to one another when they are angry with one another. And it's difficult to turn around and say, let's fix this. Okay, so there we have it. People, next slide, please. People take in legal positions. Can you see this iceberg? There are two peaks there. And this is a typical thing of litigation. The legal representatives take legal positions. And the one will say to the other one, in terms of the law, this is what we want. And the other one will say, no, in terms of the law, this is what we are entitled to. And they will carry on like that for years. Writing letters in and out of court, getting nowhere. What do we as mediators do? The next slide. Same scenario. We need to explore. We need to go below the surface of the water to see what they are really fighting about. What are their interests? What are their needs? What are their desires? What are their fears? Now, I've been mediating for a while before I realized one day, this was a divorce matter. The parties were divorced already for 2 years, but for some reason they have decided not to divide their estate, and that they would do it 2 years later. And to make a long story short, they were living on the farm that he inherited from his family, and it was supposed to go to his son, Nat. So she did not have a right to claim that farm, but she remained on the farm. She lived in the main house, and she was driving the V8 Prado. 2 years later, there was a lot of acrimony there. He had moved into a cottage on the farm, and his cupcake was living on this farm as well with him. But she was driving a little Uno or something. Now, you've seen this, what farm roads look like. It's not very wide. So quite often the little Uno landed up in the bushes. And when I arrived there that day to mediate this matter, they have decided to come to bring their attorneys to the mediation. This typical thing, the attorneys, the legal practitioners took in legal positions. My client is entitled to this. No, my client is entitled to this. And they carried on like that for 3 hours. And eventually I said, listen, guys, I'm going to excuse you. I promise you that your clients won't sign anything unless you've seen it. Is that okay with you? They got the message, they packed their bags, and they left. I realized that she was trying to tell me something during this mediation, but because the attorneys were fighting with one another, she didn't get to that. So in a side meeting, I asked her, why are you so fearful to leave the farm? And she burst out crying. And it took her about 10 to 15 minutes just to gather herself again. And then she said to me, Laurie, you asked me, what is it that you want out of this whole thing? You know what I want? And then she told me the story. 20 years before, she and her husband went out one night, and on their way back, they were involved in a terrible motor vehicle accident. She woke up 3 months later in ICU. and the husband was there, so he was okay. And then she said to him, "My 2-year-old, where is he?" He had to tell her, unfortunately, that child died in that motor vehicle accident. And then she said to me, "You know what I want? I went back to the farm after my discharge from hospital. I did not have the opportunity to say goodbye to my child. The child is buried on the farm. I went back and I planted a forest around the grave. I just go into that forest from time to time, and it's my way of dealing with it. I want free access to the grave. That's what I want." "Really?" "Tell him I want free access to the grave. I'm concerned. My fear is if I leave the farm tomorrow, that they will change the codes on the gates and that I will never ever have the opportunity to go back to my child." I did exactly that. I went to him in a side meeting and I said to him, "She wants free access to the..." "What?" "She's not saying. She's got that. Now you can tell her she can get the farm in Mojaji. She can get a 50% in another farm, which is a running business, and it will take care of her. She can take whatever furniture she likes, and she can take the Prado if she wants that." I went back. This case was settled within a half an hour after the attorneys had left. Why? It's not about legal positions. It's about the interest of the parties. It's about their needs. It's about their desires and their fears. Nothing else. Why do you have to spend years and years in litigation if you can finalize a thing right now? Right now. And that is part of our maintenance system as well. I can't tell you how many cases I settle by just making one phone call. She phones me and she tells me, "Laurie, I heard about mediation, but I can tell you right now, he's not going to be interested." And then I say to her, "Will you please give me a chance?" I make one phone call. One phone call. Litigation is ugly. Litigation is unnecessary. 90 to 95% of cases that do submit to mediation settle. Why do we still continue and carry on with litigation, knowing that it's not working? I've been on the bench for many years as a magistrate. I've been in this system for 42 years now. Okay, let's continue. On to the next slide, please. So, some basic principles about mediation. It's a confidential process. Whatever they share with one another there cannot be used against each other in a court of law later. It's a voluntary process. It's not difficult to get parties to a table if they really want to resolve their disputes. Okay? It's an empowering process. Why? They make their own decisions. There's not someone telling them what they want or what they're going to get, and they're not going to be happy with it later on. It's a neutral process. The mediator cannot make any decisions about the law. The mediator cannot make any decisions about the facts of the case. The mediator cannot make any decisions about the credibility of the parties. It's not my job to say to someone, "I may know it, you're lying through your teeth, but it's not my job because I'm not the magistrate, I'm not the judge." And it's not your job as a mediator to do that either. Okay. The last one, unique solutions. I can't tell you how many cases, maintenance cases, even cases of arrears maintenance, We have settled with unique solutions. She says during the mediation, because you didn't pay your maintenance, I did not have money to service my car, and now the engine is seized. And now he says, sure, my brother is a mechanic. Can I ask my brother to fix the car? She says, I need a car. Anyone can fix the car. They agree that he will buy the parts. The brother will fix the car. Settled. Okay. Can this happen in a court of law? No, it can't. Never. Okay, let's move on. Next slide, please. The advantages of mediation: mutually satisfactory outcomes. There's a high rate of compliance. Why? They have decided this is what they want. Comprehensive and customized agreements, experience of creative problem solving. You have to be creative when you're a mediator, when you're in mediation. There's not only one solution to any problem. There are many solutions to one problem. Greater control and predictability over the outcome. They decide for themselves what they want. There's personal empowerment. It resolves relationships. Now, can you imagine they walk away from the table and they say, we really got joy here. Why was it necessary to go to court? Okay. It's workable and implementable decisions and decisions that hold over time. The next slide, please. When to mediate, where there's moderate conflict, where there's party commitment, where there's lawyer commitment. Please, colleagues, my lawyer colleagues, listen. Where there's a continuing relationship, where there's power equality, where there's multiple issues, adequate resources, no clear guidelines, etc., etc. Now, some of you will tell me, you know what, he's a narcissist, and. Maybe he is. Maybe he is. So the duty on me as a mediator to make sure that the best interest of the children are taken care of. Listen to this now. Yes, it is confidentiality. It is confidential. Confidentiality is one of the pillars of mediation, but it's limited. How is it limited, Laurie? I've mediated various cases in the past. We start out, we get to an agreement, he's going to pay X amount per month. They agree to that now. Okay, so it's valid. A month later, we continue with this divorce or separation mediation, and I realize he's not coming to the party. But he can. He's able to. He's a business owner or whatever. I tell him in that mediation session, I'm going to send you an email now with prejudice. There's an obligation on me in terms of the Domestic Violence Act. If there's financial abuse, to report it to the authorities. I'm giving you until 12 o'clock today to pay up. If it's not paid up, I will draft an affidavit to submit to the authorities. What is your choice? In all of the cases where I've done that, the one guy was so afraid, he was on his way to the ATM to do the business now. So he keeps on phoning me. He says, Laurie, please, I'm at this crossing now. I don't even know where this is. Okay? And then 5 minutes later, Laurie, I'm close to the ATM now. He made the payments. Okay? Mediation is not a weak business. It's not weak. Okay? It's not an easy way out. If you have a responsibility, there's no way that I as a mediator can take that away from you. Okay? It's not my job to help people not to come to the party. I'm not there to help them to hide things. It's not my job. It's not my decision. Okay? For some reason, people think if you participate in mediation, you're going to lose out. It's not so. Okay. Let's move on. When not to mediate, if it's a matter of policy, if he says, oor my dooie liggaam, okay, we can't mediate that thing. If it's a pure legal question, maybe it's something that needs to go to the Constitutional Court. If there are ulterior motives, if there's personal danger, if it's a fact-finding mission, if there's emotional problems. Now, I did say to you 90 to 95% of cases do settle. Almost 10% of people walking on this earth suffer from some kind of a personality disorder, etc., etc. That's why we have it. Okay? That's the explanation for it. Other people settle. So let the narcissist go to court and let the magistrate punish him. Okay? But for the rest of us, let's just do the normal thing, man. Okay? Where there's value differences, where a court remedy is needed, and where there's great urgency. So where in this whole litigation process can mediation fit in? Anywhere up to the point where the judge says, I'm ready to deliver judgment, you can still say, Your Honor, please stop. We want to mediate. And he will adjourn. He will give you the opportunity to mediate. You can come back with your settlement and say, we've mediated. This is what we've come up with. And the court and mediation rules say the magistrate must make the agreement an order of court, even if he was going to say something quite different. Okay? So you can mediate at any stage. I often deal with cases where the attorneys come back to me and they say, no, we already have a trial date. I say, so what? Okay? It doesn't matter. Okay, there we go. Fisher and Urey, what do they say about the interest-based approach, which is the one that we follow? It's about people. Separate the people from the problem. Remember, the person is never the problem is the problem. Do not make a person a problem. Okay? If a person has an addiction, the addiction is the problem. That person is not the problem. If he's sober, he's a wonderful husband, he's a wonderful father. But if he's under the influence, that's the problem. So deal with the problem. Interest. Focus on interest, not on positions. Generate a variety of possibilities before deciding what to do. There's not only one solution to a problem. This is Fisher and Urey. Big writers. And then the objective criteria. The result must be based on some objective standard. If the value of the house is R1 million, I cannot, in a mediation, say, okay, we're going to sell it for R100,000. It's not an objective criteria. So if the cost of raising the child is R10,000 a month, it's not for any of us to say, we're going to reduce that or we're going to inflate it. Okay, we work with objective stuff. Next slide, please. Okay, I'm not going to deal with the agreements by Fisher and Urey. The next slide, there's a good, I'm not going through that now. While in mediation, if you do come to training, maybe one day I can teach you that. I just want to read something to you, which was written in a dissertation about mediation. And this was written by Sue Folb. Myself and Anneke were trained by Sue Folb many years ago as family mediators. And she has written, it's been interesting and disturbing to note an ignorance and at times an antagonism by attorneys towards divorce mediation as an alternative to contested court proceedings. Ignorance hinges around the notion that mediation is linked with arbitration, and antagonism seems to stem from the conviction held by many lawyers that non-lawyers should not be permitted to deal with the legal aspects of divorce. Same thing, maintenance, okay? Indeed, to do so constitutes, in their view, illegal practice of law. Furthermore, the idea of representing the couple and not an individual and focusing on the best interest of the family with regards to its financial survival and ongoing well-being of the children is alien to many attorneys. Indeed, approaches by clients for mediation in an attempt to reach agreement more amicably have actually been rejected by lawyers suspicious of the intentions behind mediation and concerned to prevent any encroachment on their professional territory. The next slide, please. So there was a very important case in 2010 in the Johannesburg division of the High Court in the case of MB versus NB. And acting Judge Brassey said the following, and this was a maintenance case. Listen carefully. On the facts before me, it is impossible to know whether the parties knew about the benefits of mediation, but I can see no reason why they would have turned their backs on the process, especially if they had been counseled on the matter by the attorneys. What is clear, however, is that the attorneys did not provide this counsel. In fact, in the course of the pretrial conference, they, in other words, the attorneys, positively rejected the use of the process, the mediation process. For this, the attorneys are to blame, and the attorneys must, I believe, shoulder the responsibility that comes from failing properly to serve in the interest of their clients. The court went ahead and made a punitive cost order against the attorneys. Next slide. That's also Sue Falb, and I'm not going to go into that. Some interesting facts about maintenance. Do I have another minute or two?
You've got 30 minutes.
30?
Yes.
Wow. Okay. So, guys, you can see I'm passionate about this field. Okay? The legislature does not listen to people, or to good reason, from time to time. And I've decided that we will make a difference with the help of my beautiful wife. I'm also busy writing my doctorate on this very topic. I'm going to quote from that. So what we're doing here, since I have more time, I'm going to share this with you. The proposed title is a dedicated credit bureau for maintenance orders to serve as a central maintenance register and promote alternative dispute resolution with online dispute resolution facilities. The idea is to centralize everything. If a person dares to go to a bank to borrow money, everything will be there. If she goes to the court to start the maintenance inquiry, by the press of the button, she will have access to all the financials because of a centralized system. Okay. And there's lots going with that. Okay, so the official figure that I got as part of my research on the amount of cases handled by the Justice Department, and courts receive more than 200,000 for maintenance annually. Statistics about South African children living arrangements indicate that a mere 34% of children live with both biological parents, 42% live with their mothers and not their fathers, a mere 4% of children live with their fathers but not with their mothers. Theoretically, up to 66% of children in South Africa are in need of maintenance from a non-custodian parent. Statistics in South Africa shows that in 2020, South Africa's total population was estimated at 60 million people, of whom 20 million were children under the age of 18. Children make up 34% of the total population. 66% represents 13.2 million of children that are not living with both biological parents. Now listen to this. There were 1.265 million live births in South Africa in 2022. If 66% of new births are living with one parent, there is a need for 835,000 new maintenance orders per year. Then the official estimate of 200,000 new orders finalized produce a deficit of 635,000 orders annually. And this is just on new cases. We're not talking about the rest, 13.2 million, who are in need of an increase or a decrease or whatsoever. Are you with me?
Yeah.
Listen to this. By 2018, there were 384 magisterial districts in South Africa. There are 260 working days in South Africa every year. Hypothetically, if maintenance orders are to be revised every alternative year, then on average, every magisterial district must finalize the maintenance orders of at least 66 children every single working day. This is impossible because the maintenance court system does not have the capacity to deal with such a workload. You see why we should consider mediation and a central register, etc., etc. Okay, thank you for listening to that. Annika, the next slide, please. I'm just going to compare the different processes that we follow at court to mediation. So let's start with mediation now. We did say to one another, if a maintenance matter, for instance, is mediated, we can test it against the 5 pillars of mediation. If you mediate your maintenance dispute, is it confidential? Yes. Is it a voluntary process? Yes. Is it an empowering process for the parties? Yes, it is. Is it a neutral process where someone else will not be making decisions for them? Yes. Is it possible to have unique solutions there? Once again, yes. Okay. Now, you know what happens if you start a maintenance process at the courts. First of all, there's an investigation by the maintenance officer. Okay? And they sit around a table in the maintenance officer's office. Okay? Is that confidential? The answer is no. Why not? Why is it not confidential? The maintenance officer is gathering information to take on trial if they don't settle. Okay? Is it a voluntary process? No, they must be there. There's a law that says they must be there. Okay? Is this empowering? No, it's not. Is it a neutral process? I would love to believe that all maintenance officers are objective. This is neutral and they are impartial. Okay? Any unique solutions possible there? Absolutely no. Okay? They can only follow what the law says. A magistrate, a maintenance officer, a clerk at the maintenance court, they are all creatures of statute. They can only do what the law says. Okay. Now they don't settle there. Now they move on to the full-blown inquiry in court. Is that confidential? Yes. It's behind closed doors. It's in camera. Is it, Deon? The mediation inquiry. So that's confidential. Yeah. Is it a voluntary process? No, they've been summoned to be there. Is it empowering? No, the magistrate is going to say who's going to pay what. Is that neutral? Yes, magistrates are neutral. I was one. Any unique solutions possible? No. Okay. Before I go to my next slide, where we're going to talk about mediation, accreditation, etc., etc. I've invited you to speak to me, but you didn't ask any questions.
You got our questions.
Yes. Can I take questions now, if it's okay with you? Any questions about mediation, etc.? There's a question there.
You spoke about the central.
Just a minute. He's going to bring the mic to you so everyone can hear.
There's two questions I'd like to ask.
One at a time. I seem to forget.
Okay, I respect your age.
You're welcome.
I didn't finish my argument because I'm in your age category.
Good.
Thanks. The one question is, you spoke about the central point of information. Is that not a violation of the Poppie Act? If everybody can have access to your personal information. So that's the first question.
Okay. I'm still writing the paper, but with the research that I've done up until now, it's not. So credit bureaus are regulated by the National Credit Regulator. And already they have a lot of information, financial information, other information, such as where you live and lots of other motor car registration numbers and telephones and all of that is regulated, and they do not violate any laws. So we must take a different angle here. Will it be in the best interest of children if the maintenance officer has access to all the information, financial information relating to this inquiry? Will it be in the best interest of children? Annika? You want to add something?
Maybe let's just say that we mask the minor children's data, and that's not going to be.
Okay, thank you for that, Annika. So we are working on the system. It doesn't belong to us, it belongs to South Africa. The information is masked. In other words, the details of the children will not go out to the credit bureaus. There will be an estimation of age, but that's it. Okay, so the potential credit providers will be able to see this guy has got another 10 years to pay maintenance at least, if you hear what I'm saying. That's the only information. So the names of the children, birth dates, etc., will not be given to the credit bureau. Okay.
Okay, the second question is, I can't understand how magistrates make orders when all the facts is put there on the cost of the maintenance required for the child. And clearly, just hypothetically, the child needs 2,000 rand from the father. And then the magistrate says, no, this man can't afford the 2,000 rand. I make an order of 1,000 rand.
Okay.
In my opinion, what that magistrate is telling the mother, you must now subsidize that father's cost in reality. And I, as Deon said, I went through this process in the 80s. And I still see the same practice happening.
Yeah.
It shudders if a magistrate recently told somebody that I've been advising, no, we can only give you 50 rand a week. I would, it's a pity you can't be there with them in the court. I will blow that magistrate's head off if I was supporting that woman. I would have said you can't even buy I scream every day with that event. Thank you.
Thank you, ma'am. Okay, so in South Africa, we have a discretionary approach towards maintenance. So, what does that mean? If you claim maintenance, you are required to go to court. If the parties can't agree, if there's any disagreement about the amount, for instance, um, it's up to the magistrate to make the decision, and he can use his or her discretion to get there. So, with a centralized system, once again, if the credit providers who give people debt, okay, if they extend credit to someone who has children to take care of, but they either ignore it or they didn't know about it, which is happening at the moment, you cannot really do something about it. But if the credit provider was aware of the fact that this person will not be able to take care of his family and pay the debt, it will boil down to reckless credit. And for reckless credit, those companies can be punished. Okay, so with a centralized system, we will do away with that problem because the information will be out there. If they don't make use of the information, it will explode in their faces. One of the punishments for reckless credit is that the debt can be written off. Another thing is they can be punished with a fine of up to 10 million rand. So they will think twice before extending credit to someone who cannot or will then not be able to take care of his or her family. But it's very relevant. Thank you so much for that.
I also have a question. So, but firstly, I just want to say thank you so much for your heart and passion for mediation. And I think what you've done today was really dispel some misconceptions on mediation and really shed light on such an important matter. May you continue to do the work that you're doing and continue to train more and more mediators in South Africa, actually, to take this matter to another level. And I also just want to say thank you for your contribution to the SA Law Commission paper 157. And my question is on chapter 2, if there's a suggestion that maintenance officers should do mediations in maintenance matters. What are your thoughts on that?
Okay. My thoughts on that is the slide that you see before you. Okay. Can maintenance officers really mediate those cases? I had this discussion with someone at the Law Commission the other day. What should happen is that maintenance officers should be trained in negotiation skills. They negotiate a lot, but can they mediate those cases? So in mediation, the mediator must be completely neutral. Okay? He cannot even sit with one of the parties waiting for the other to come to mediation, because he or she can be influenced in that time. Okay? And the parties will, or the other party will lose his trust in that process. Now, the maintenance clerk or the maintenance officer deals with the one client all the time. Okay? Listening to the complaints, etc., and then the other person comes in. Already there can be a preconceived idea about what's going to happen here. I've heard something this morning. The lady who spoke about the Stellenbosch Law Clinic, that respondents, they do not help respondents. That's dangerous. Okay, what's happening to justice? Okay, not all complainants are honest about what's really happening. Okay, we know most of the fathers don't come to the party, but there may be a father who's honestly doing his part and he goes to this to the legal clinic, and they say, no, we sorry, we won't be able to assist you. You're a respondent. That's not justice. Same thing can happen here on this question. I've gone through that list there. So why can't the maintenance officer mediate? Because the maintenance officer in that very first investigation is actually gathering more information. And that same maintenance officer will take that information gathered in that investigation to the inquiry where the magistrate will now listen to that, and that will be tendered as evidence. Whilst mediation in its purest form is confidential. The parties walk away if they don't settle, and nothing submitted can be used for or against them. Okay, so that's a big one. Maybe the most important one there. I hope I've answered your question. Okay. Any other questions? Yes, Natalie.
Yeah, so my question, I'm here to learn. I know that I had a really big fight about this with arguments. It's a story you hear quite often in maintenance with moms who are struggling to get the correct amount of maintenance from the fathers. So the scenario would be that mom has had to downscale on her lifestyle by moving in with her parents to substitute or to come up with the balance of the expenses that are needed for the child. Now, in reality, we know that if there was a father plan for this, so there's affordability, and mom is still wanting to maybe do mediation, father's still keen on mediation, and when we put together the expense list, my question was, we can't really say what mom is contributing to grandma and grandpa, because the reality is she's had to give up her flat or her house to compensate for school fees that that isn't paying for, or medical aid, or whatever it is. Deon basically said, basically said that if she decides to appeal to court, or we report financial abuse, and then we have to put in a J101, we have to work on factual figures, and the factual figures are what mom does give to her parents for rent, which would be maybe 3,000 rand. But she just moved out of her house, or we should think 10,000 rand. But she had to do it due to circumstances, and she was forced to do it to pay outstanding school fees, medical aid, outstanding bills. How do you navigate that?
Okay, so we have two scenarios. There's this factual scenario, and maybe she's been getting 200 Rand a month for the last 10 years. And because of that 200 Rand a month for the last 10 years, she's in dire straits now, and she can barely afford to feed the children. If you have to use that, So we have to compare it to what she needs. What is the real needs of the children? Okay? Compared to what she's spending on them now because of the circumstances. I don't have all my notes and stuff here, but I usually compare that. And if I happen to be the magistrate, I would take note of the actuals, but I would focus on the need. Okay, and there's authority for the need. What does the children need?
So I understand that, and in one particular example, the mom had to, child became very sick and chronically ill. So mom had to increase medical aid. So mom then had to increase medical aid, and outside of medical aid, she has to pay monthly amount towards the chronic medication that the medical aid is not covering. So because of that, it works out to about 3,000-4,000 Rand extra a month. Mom, that's what she was going to rent 3-4 months ago until the child was diagnosed with this issue. So we registered that has been educated by the doctors who diagnosed the child, has said the kid has to be on this medication. And mom's like, I can't wait until you decide you want to pay half the expenses to this medical aid. So My thoughts were that if we still stick to Mark's rent that was 10,000 rand, and that Deon, the advocate has basically said that's not the reality. The reality is, if you have to go to court, she is now paying 3,000 rand towards rent as opposed to 10,000 rand. So,
this is all facts. Answer for us.
Okay, so clearly this case cannot be mediated. This is where I, as the mediator, would have walked away from the table because I cannot help them as a mediator. The magistrate or the judge must make that decision. But I will try and move the parties to, during this discussion, to a point where they can meet one another. Then, obviously, if they cannot settle, well, then they must move on to litigation. We can never walk away from litigation. You will always need litigation. But 10% of all disputes may end up in litigation. If this was a reasonable father, a reasonable dad, he would have come to the party. He would have made a plan, borrow money or whatever. But he's not reasonable. Yes.
So, ladies and gentlemen, as you can see, this is such an important topic, and we really want to camp a little bit on this, if that's okay with you. So, what we'll do, we're going to postpone Ms. Natalie Ruiters' talk on parental enforceability to next month. And I think it actually makes sense because the fathers will be here as well, and I think it will be beneficial for the fathers to also hear that topic. So, I want to, if that's okay with you, to just spend a little bit more time on mediation and having this interactive session. Thank you very much.
Thank you.
Thank you so much, first of all, for your time and Anna's time for this morning and this afternoon. It's in connection with the mediation process and the fact that it should be confidential and it should be neutral. My question is, say for instance you sit in the room with both parents and we're talking about maintenance now, and you've asked for both parents to bring their financial statements. But you as the mediator can see that one of the parties, that figures, that statements is either false or it's incorrect. How would you treat that? Because obviously, like you just said before, the best interest of the child should always be paramount. Would you stop the mediation at that point and continue at another stage?
Okay, that's a very good question. So the parties don't come to the mediation openly with everything that is needed. If the mediator can see that, then he does not have a choice but to either postpone for the correct information or withdraw from the process. It's also a voluntary process for the mediator. I have withdrawn from mediations in the past because there would have been an injustice if I would continue with that process. So mediators are there to act in the best interest of the parties and obviously the children as well. If the parties are not forthcoming with the truth, then the mediator should withdraw from that process. Yes, there's another question here.
Please, sorry to allow you an opportunity now. There's a question from one of our deaf participants. She opted out for me, so I'll ask it too. I got divorced in 2016, December 2016. I had to be under IDA, which means it is a period of 20 months where a woman must, after the death of her husband or after divorce, he has paid for the 4 months starting in January to April 2017. Since May 2017 to July 18, 15 months, he did not pay. So can I claim it as child maintenance? In August 2018, he started making payment for child maintenance.
That's a factual and a legal question, and I think Advocate Ruiters, you're the best person to answer that for her.
Okay. Well, it is child maintenance, so Ms. Coates, you can claim it as a maintenance, as child maintenance. The second question is, will it be okay to ask the court not to send or put my ex-husband in jail and to rather let him sleep there overnight and still go to work every day as a punishment since he's in arrears? Will a garnishing order be written?
Okay, I'm not the mediator now, but when I worked as a magistrate, I imposed periodical imprisonment on a regular basis, sending them to jail over weekends. Okay, so they clock in on a Friday afternoon after work, and then they clock out on a Sunday afternoon, just before the evening, spending the whole weekend there. But this is for not complying with the maintenance order. In other words, arrears maintenance. Did it work? It worked better when I made a further order. Sorry, a further order to for the sentence to be postponed once the money is paid in full. So the effect was they would go to prison for one weekend. The next weekend, all their arrears would have been paid, and they didn't have to go back. Okay, then all of a sudden they managed to get the money. So if you're married and you don't have the money to buy groceries, you will go and borrow money. Isn't that so? But now you separated or you divorced, and now all of a sudden it's not your problem because you're not in that house any longer. No, it doesn't work that way. Yes.
In the absence of a no parental plan, can one party...
In the absence of
no parental,
a parenting plan.
Yes, no maintenance, no parental plan, nothing.
Parenting plan.
Correct. And no maintenance, because I do maintenance with a parental plan. So in the event of no parental plans, can one party run off to the police and demand maintenance, and then demand that the father gets arrested because he hasn't paid maintenance?
Okay, I'm going to start over here. First of all, agreements. It's now possible to have an agreement between the parties. Agreements do not have to be in writing only. Verbal agreement is also acceptable as an agreement. If he says, I'm going to pay X a month, or I'll pay the end of the month, and she accepts, there's a meeting of the minds and there's an agreement in place. It's always better to try and get it in writing, even if it's on WhatsApp or a text message or maybe on email, so you can use it later. Okay? In most cases, there are agreements in place. Now, if there is no agreement in place and there's no court order, then obviously, now you cannot go to the police. You must work through the maintenance courts. Make use of the maintenance court system. The police do not have the authority to deal with maintenance matters, maintenance cases. They cannot arrest unless they have a warrant of arrest. Yes.
Thank you for a very informative session. One likes this dialogue and interactiveness, and it speaks to the definition of why we are here today. But my question is not much of a question. What? How do I phrase it? What is the? What is the
Say it in Afrikaans.
The language is not a problem. Getting to what I'm wanting to say is a problem. What is the so a lot of times, like when we do mediation, right? What I normally do is I don't deal with the maintenance aspect of parenting plans because what you get is that that normally influences the parties to give effect to to the decisions of when to the visitations and all of that. So there needs to be a separation between maintenance has got absolutely nothing to do with visitations and seeing your child. You need to see your child because why it's part of your parental rights. It's not your responsibility. It's also part of your parental rights. To see and to have access to your child. So what we normally do is, and I know the TSD and child welfare, social workers, they also do that. All the maintenance issues, we refer to the maintenance code, but we come down to right. Let's speak about the care and the contact and all of that. In your opinion, do you think that is a good idea or advisable?
Okay, let me answer it this way. What is a parenting plan? A parenting plan is a written agreement between the parents about their parental responsibilities and rights. That agreement is then made an order of court or it's registered with the office of the advocate, a family advocate. That's a parenting plan. Okay? What parental, parental responsibilities and rights are included in a parenting plan in terms of the law, making it possible? Care, contact, guardianship, and maintenance. Okay? That's a full parenting plan. If you don't cover everything, you haven't done your job properly. You're supposed to cover everything. That's a parenting plan. Okay? I know that some magistrates, they will just strike it through. Oh, you've tried to do a maintenance inquiry here, and then they strike it through. They are not entitled to do that by law. Why? The law says the magistrate must make the agreement between the parties an order of court. What word did you hear? Must. Not may, must. So if you don't cover the maintenance aspects as well, you're making it difficult for the parties unnecessarily. Now they must go to the maintenance court. Some maintenance inquiries, it takes years to get to the maintenance court. Years. A lady phoned me the other day. She said to me, Laurie, I cannot do this any longer. I've been to maintenance court 54 times now. I can't do it. So you're putting that woman taking care of that child in a position where she must go back now. She's losing all of her leave. And now she doesn't just lose her leave. She must now take unpaid leave to do the rest of the exercise. It's an injustice. You can only do that if the parties do not settle their maintenance as part of mediating that parenting plan. But then you can make it clear. They've settled care, they've settled contact, if the other one, guardianship, is relevant, they've settled that, no problem. And make a note, they could not settle around maintenance because it happens from time to time. So what I've done in the past, I've mediated so many of these parenting plans. I would sit down with them. They were never married. They have this child. They've moved on in life. And it's now a couple of years down the line. And now they're mediating a parenting plan. He says, I don't get to see my child and I want to see my child more often and so on. And then I would ask, ma'am, is the money part sorted out? What do you mean? Do you get enough maintenance here? Because we're in loggerheads. We got stuck somewhere. And she says, no, I'm not happy with the money that I get. So can we talk about that? Can we add that to the agenda, etc.? So we talk about the money. We settle the money. Okay? I go back to contact now. She says, you know what? He can see the child whenever he likes. Sort out the money. You're going to send unhappy people away from you if you don't sort out the money. Money is everything for a parent. Okay? Deal with the money. It's not easy, but get into it. Deal with it. Brunel.
Okay, one second. We also have a question from one of our online viewers. If attorneys don't insist on mediation, but rather run up a bill for litigation, what do we do then?
It's the choice of the parties. They instruct their attorneys. Okay? It's not for the attorney to decide this case cannot be mediated. It's for the parties. And I often get the objection. I invited a party to mediation one day. And the next thing, I got a letter from the attorney. Who's Laurie Greyvenstein? And I can also mediate this case, etc., etc. So I am not an attorney, I'm a mediator, okay? And if there are attorneys here who work as mediators, then you're a mediator in that case, you're not an attorney, okay? You wear the cap of the mediator, not the attorney, okay? So as a mediator, I deal with the parties. It's their choice whether they want to involve their attorneys or not. So I wrote an email back to that client after the attorney opposed. But I copied the attorney in so that they can take note of what I say to their client. And I wrote to her, I said to her, she mustn't ask silly questions like, who is Laurie Greyvenstein? She's been at my wedding. She knows me. She knows I'm a mediator. She should know better to tell you that she can mediate. She cannot. She's already put the cap of the attorney on. She cannot go back to mediation now. Okay? And then I continued about how attorneys can be, like with the case that I've quoted earlier today, there can be punitive cost orders against them, etc. It's their choice at the end of the day. 10 minutes later, I got another email. When can we have the first session, please? Yeah. So, even attorneys, you must know or learn how to deal with other attorneys opposing mediation. Okay? There are some of them out there. There's another slogan, don't talk to me, talk to my lawyer. It's a costly slogan. It's going to cost you dearly. Any other questions? Brunel.
Thank you. Just what you said about some of the courts, or especially the children's court, when you spoke about getting contact now, that some of them do not want to make a maintenance order. I know there was an article published by Adv Deon. I can't remember the section now, I think it's section 62, which says that any court can make a maintenance order, whether it's a domestic violence court, whether it's it says any court.
Yeah.
And I think we, as the public, should put pressure on these magistrates, and I don't mean it in a disrespectful way, but it is in law. We should make use of that. Because now they say there's a domestic violence case, for instance, that might have been finalized, but then they send you away to the maintenance court.
Yeah.
Where they could have settled it here in the one court. Yes. And that will make a huge difference.
Absolutely. Absolutely. Thank you for that contribution. What's happening at the moment is we're working towards a family court exercise where one court can deal with all of it, everything. So we will make great progress with that soon.
Can you explain the mediation code
Oh, there we go.
Social Justice Act and how much it costs and what is the criteria for somebody to become a mediator? There was a question, how can I become a mediator from one of the ladies over there in the back?
Yeah, okay. So, based on court and next mediation rules, I can say the following. A person with an NQF level 4 qualification, in other words, a matric qualification, can become a mediator. If you do not have a matric and you've got some other reasons why, you can apply for exemption. The law makes provision for that. The need for mediation is so great that the legislature did not want to stand in the way of any other people who do not have those qualifications. Obviously, it helps if you do have other qualifications. If you are a lawyer or a psychologist or a social worker, dealing with family matters, obviously. Okay? But that's the criteria in terms of court and ex mediation rules. I just want to bring it to your attention. We have two streams of mediation in South Africa: private mediation and statutory mediation. Court annexed, or what's the other term now? No. A court connected mediation, that's statutory mediation, and there you must fulfill every requirement in terms of the law, full stop. Okay? With private mediation, it's different. But we're expecting some legislation soon that will also regulate that. In South Africa, the organized mediation, family mediation, falls under the banner of NABFAM, the National Accreditation Board of Family Mediators, and paper 157 makes mention of that. Okay? Listen carefully. NABFAM has high regard with the South African Law Reform Commission. If you're part of any other exercise, try to come to the party under the NABFAM banner as soon as possible, because those accreditations will not be respected. Hear what I'm saying to you. If you're not a NABFAM accredited mediator, you're going to have to redo that qualification. Rather now do an RPL, recognition of prior learning, okay? Use that other qualification and come to the party under the NABFAM banner, okay? I've helped some other people in the past to get there. The more mediators, family mediators, people who are willing to work with families, the better. I can train 100 mediators every month, okay? I will never be able to out-train my own business as a mediator because the need is so huge. I've said to you, 13.2 million children are in need of services. Okay? I've done the calculations for you. A big court such as the Pretoria court finalize up to 4 cases per day. On average, every magisterial district should be able to finalize at least 66 cases every single working day throughout South Africa. Okay? And if a big court such as Pretoria finalizes only 4 cases, you must know what the backlogs really are. Okay? Huge need.
Okay, so if somebody has gone to a course with some other institution and not with social justice and not with NABFAM, is there a way that they can get associate membership to NABFAM instead of having to go to a new course what is the RPL all about, and how long is the RPL, and how much does it cost?
Okay, so RPL recognition, let me go to the first question first. So can you, if you belong to another organization, etc., yes, obviously you can apply with NABFAM to have that organization accredited as well. But the problem with the qualification is NABFAM cannot backdate the qualification that you've done and now make it a valid qualification. The qualification must be accredited first, and you must pass an accredited qualification before you can be accredited in terms of the NABFAM rules. And I'm saying this because if you go back on paper 157 that you've spoken about today, they are very clear about the NABFAM involvement there. Okay, in all the papers issued by the South African Law Reform Commission, they refer to NABFAM. Okay, and they've been around for more than a decade. The other accredited organizations have been around for more than 2 decades, 3 decades. They came together, they worked together, become part of the mainstream. That's what I'm saying. Okay, so we can all work together, same standards, same ethics, everything that goes with that. And we're not at NABFAM trying to be exclusive. We want to include, but there's an extension. We can help you with RPL. What I often do is to say, you've already paid a hell of a lot of money there. Maybe you can come for a percentage of the cost. Now, our training is, the mediation training is now 9,999, okay, plus the manuals and stuff that we issue, plus VAT. So you can even negotiate on that if you're doing an RPL. Okay. To become a family mediator, there are 3 components. There's a 40-hour mediation training. Okay. Then there's a 12-hour applied law for family mediators if you don't have a law background. And there's a 12-hour applied psychology if you don't have a background in psychology or social work. Okay. And then after your qualification, you need to become accredited. You need to do some practical work, and after that practical work, you have to do that with a qualified, accredited mediator who will issue a certificate to hand in. Okay, so we've been in this industry for many years. I've said to you, we started the Social Justice Foundation or Association of Mediators under the Social Justice Foundation 3 years ago. Now, in comparison with the other organizations, they're running for many years already. Okay? Because we call ourselves social justice and we want to make access to justice possible for people. We move into the remote areas of this country to train people, bring them on board, etc., etc. After 3 years, we are the largest family mediation service provider in this country. Okay? You work for yourself, you don't work for me. I empower you. We've got so much to share with you, to give you, just to take mediation and the best interest of children forward. I hope I've answered that question. Okay, the law part of the training is 1,999 plus the cost of your materials. You get manuals and stuff with everything. I'm back on contact training, especially here in Cape Town. For the year, we've already trained 70 mediators already for the year. And I'm back on face-to-face training in Cape Town. We have offices in the northern suburbs. I'm starting with another course there on on 5 June, 5 to 9 June. Once you've trained with social justice and you remain part of the social justice family, You can at any stage come back for a refresher. At any stage. It's part of the deal that you get. Okay, you become part of a bigger family. We want you to be involved. Etc., etc. I can carry on for very, very long.
Sorry, the online viewer that asked about which women is not insisting on mediation, just another follow-up question. Okay, but what about the case law of Brownlee versus Brownlee, where attorneys were penalized as a result of not informing clients that mediation could resolve matters sooner?
Yes, I've given the authority here today. So is the question, what about that case?
Yes.
That case is a reality, and it will serve as a precedent. If that's the example, if attorneys do not come to the party, that case may be used to penalize them in the future.
Yeah. That is wrong. That is wrong.
Hi, sorry. I just want to ask you, your accreditation of the mediators, are they automatically then accredited with NABFAM?
Yes, yes.
So you're the only organisation that accredits directly with NABFAM?
No. There are 4 organizations. SOM, South African Association of Mediators, around Johannesburg.
Yes.
FAMAC, Family Mediators Association of the Cape, around Table Mountain. Then there's KZN, Association of Mediators, down in KZN, mostly around Durban. And then social justice, we go to remote areas, etc. And the idea was to make it available to everyone, and affordable to everyone.
Okay, thank you.
Is that it? I thank you so much.
Poppie and I are fighting over who's going to close today. She wants me to close, and I say no, she must close. I just want to quickly tell you there is the Magistrate Court rules that was published the 5th of May in the Government Gazette. The Magistrate Court rules on mediation will come in operation or will commence on the 9th of June. I did put it online, or Natalie put it online to any of the online viewers that want a copy of the Government Gazette pertaining to mediation. Please read it. It's not a lot of reading with the forms that's in there. It's say around 4 or 5 pages that you can read on the Government Gazette. If you would like to get a copy, just drop Natalie a email. She's distributing it far and wide all over South Africa. Email address natalie@lepoppy.co.za. Is it .org.za or .co.za? Natalie?
Okay.
.org.za or co.za. Okay, so there you have it. So please, if you want to get a copy, let us know and we'll send you a copy of the Government Gazette. Please read it because it will enlighten you so much of how mediation is going to be allowed in the Magistrates Court rules. So if you have any matter in the Magistrate Court rules, make it known to the magistrate that you would like to pursue mediation in your specific matter before you go and appoint your attorney. First, see if that can't work. If you see things are not working out, then you always have the option of an attorney. And as Laurie said, even if you have an attorney, there's any time before the court is going to give judgment that you can still ask for mediation. And that's the nice thing about mediation. So let's please start looking at that. The Government Gazette 5 May, and that's going to change the Magistrate Court rules pertaining to mediation in different types of matters that are in the magistrates' courts all over South Africa. commence on the 9th of June. So please get a copy of it, start reading it so that you know what it entails. Thank you so much, Laurie, for all your experience and coming in at the last minute. And not in niemand gesocht so before like me and all of that. It shows once you get to a certain age, those things don't matter. You just jump in and help the poor socks wherever you can help them. Thank you so much for coming in at the last minute when Eugene Opperman was sick, because we were planning to have an interactive. Luckily, it is interactive, and we got Mr. Arendse an opportunity, at least I'm in good books now, so we got an opportunity to engage. And this is how it's going to be the 24th of June, but I'll leave that over to our MC. Please do not leave immediately. Mr. Fabian Daniel says there wasn't a lot of people that bought food. Please assist them to get rid of that food, otherwise he'll have to throw it away. And he got up 6 o'clock this morning. He was over here to make sure that the food is ready. And not a lot of you bought. If you can just support him by at least buying a meal for yourself or someone else, or take some takeaway home, then at least he will appreciate that for him offering his Saturday to us. Bongi wants to tell us about next month's program and what we are planning to do and the meetings we had with Daniel, then Hollander. I'll leave all of that over to her. Thank you.
Firstly, I just want to thank everyone in this auditorium. Thank you so much, ladies and gentlemen, for joining us today. I have enjoyed today's interactive session. And I also just want to thank our online viewers. Thank you so much once again for taking the time to join us today. And I also want to thank the NPA for, again, creating this space for us to come and learn and support each other, educate ourselves, and really do our part in making the justice system work. And another thanks that I need to extend to our ambassadors. It's something that I didn't mention earlier. Most of our ambassadors are actually not in the maintenance system. They're not trying to get maintenance for their children, but they come here every month to come and support us. So I just really want us to just take a moment and honor those ambassadors. Some of them don't even come to the auditorium. They are in the background serving us so faithfully, so beautifully, with kindness and warmth. So let's just give them a hand of applause. And I also want to take a moment to also thank the ambassadors that are helping us in the children's corner. As we all know, we now have childcare facilities at the NPA SOCA community dialogues. What we're trying to do is remove some of these barriers that are affecting mothers from actually coming and joining us and getting educated here. So, one of the mothers, again, she doesn't even come to the auditorium to listen to the dialogues because she's taking care of our children. Let's take a moment, she doesn't want to mention, but let's take a moment and honor her, please. And now to the good part. I actually wanted to, I'm going to get into trouble, but Mr. Greyvenstein, you spoke about the power of dialogue. And the heart behind the Voice of the Father project was really encouraging that dialogue. Yes, I know there's a lot of backlash because it's a betrayal. Why the voice of the Father? But we cannot be here alone as mothers, as the legal practitioners, social workers, mediators, fighting alone. So, if you don't mind, because we've done this for so many years, over 30 years, you're a father, you've been a magistrate, you're a mediator, sorry, I'm emotional. And I'd like you to just come and say one or two lines about the voice of the Father in the maintenance system. What does that mean? What does that look like? Does the Father have a voice? Why is the Father not here today, ladies and gentlemen? What actually encouraged me was seeing my own story. I didn't get the maintenance I wanted. I didn't get the results that are desired from my process. And even though I was bitter and I was angry because of the sleep, the child still needs to be taken care of. But just seeing how the mediation process gave the father of my child dignity and a voice. For the first time, he actually had a voice. He got to share his side because I'm not a bit of I don't have time to listen to his story. I'm going to be honest. I'm hurt. So I don't have time to listen to his excuses or whatever. But just seeing him sitting in that room and having a voice. I'm not there yet, but something in my heart shifted. And I wondered, what if we encourage the fathers to come and dialogue? Won't that shift something within the hearts?
Yes, it is.
This is a giant, ladies and gentlemen. Our children are suffering. Is there room for us mothers, despite the pain that we are feeling? I'm standing here. I don't have the full maintenance from every father. I'm still responsible for 98% of my son's costs. But I'm saying, despite that, is there room in my heart to encourage the fathers to say, come to the table. How can you help us fight? So I'm going to take a moment, if you do have maybe one or two sentences that you can just release as a father to us and encourage the fathers to come and join us on the 24th of June, please.
Wow, I'm so humbled. I attended a funeral yesterday. Chief Magistrate Jaco van Reenen passed away a week ago. And my own father passed away when I was only 23 years old. And even at that age, I still needed a father. When I attended that funeral yesterday, I realized that Jaco van Reenen was a father to me. When I messed up, he would call me in. And he would have a fatherly discussion with me, even as my boss. His children were there yesterday at the funeral, and they spoke fondly about their father. They're in their 40s, maybe 50, I don't know. Can you imagine a child growing up without a father? Always longing for that father figure, always. You can go to any of our prisons in the Western Cape. And I've seen this so many times working as a magistrate. A good friend of ours, who's on our board, Dr. Charles Flandorp, we can invite him to speak about that, will tell you that I think it's in the mid-90s, 90% of persons incarcerated did not have a relationship with their father. This is so important. I'm honored that you've asked me, but I think that someone like Dr. Flandorp will do a great job. And also someone like Derek Bekes, Reverend Derek Bekes. Maybe if he can also speak on that topic. Thank you for thinking of me. I'm not always the best example because I've made so many mistakes myself in life. And maybe because I was lucky to raise my children, I cannot speak on behalf of other fathers. I know there are fathers who were not so lucky to raise their children. Okay? Parental alienation is a real thing. And if I can maybe just ask the mothers here to make it possible for your children to have a relationship with the father, even if he's not a good father. You know, that little contact means a lot. I had a request the other day of a 14-year-old girl child. She begged her mother to speak to me so that she could have a mediation with her father. He was not part of her life. The child asking for a mediation so that she can have contact with the father. He did come to mediation once and then he disappeared again. There was a great book written some years ago by Floyd McClung, The Father Heart of God. So if you can get hold of that, I think it's useful. Thank you so much.
Thank you so much.
Thank you so much. Thank you so much for that. So we're going to share more and more details about, because we're still busy with the program. So what we're going to do, we're going to share more on our social media sites. So please do join us. I mean, share, join, and also join our WhatsApp group as well. So we will share more details about the amazing speakers and the program. And obviously, we will open up Quicket for you to register for that dialogue. Please do invite men and fathers in your community so that they can come and be part of the dialogue. On that note, thank you very much for joining us today. To our online viewers, thank you so much. Please do join us for lunch. And we'll see you on the 24th of June. Thank you very much.